on the record in the matter of the State of Michigan v. Shannon, Parton 251420A. And appearance for the people, please.
Good morning, Your Honor. Mohammed on behalf of the people.
Thank you.
Good morning, Your Honor. Greg Bulahanis, P36431, on behalf of Shannon Parton.
Thank you.
Good morning, Your Honor. Shannon Parton.
Good morning. All right. So today's the date scheduled for the continuation of the trial in this matter. Are there any matters that we have to address before we bring the jury in?
Yes, Your Honor. And just so the court is aware, I'm not texting or using my phone in that kind of way, but I'm referring to the Michigan rules of evidence, which I have pulled up on my phone.
Okay.
A few things I'd like to just place on the record.
Okay.
Number one, Your Honor, is in regards to the defense's expert witness. So I will be stipulating to him in his admission as an expert in relation to his SFST testimony. However, it's my understanding that he intends on giving medical related opinions. And so I'm going to object to that. And there's numerous reasons why I'm objecting. Number one is pursuant to MRE 702, testimony by an expert witness. In that rule, it indicates that a witness who is qualified as an expert by knowledge, skill, experience, training, or education may testify in the form of an opinion, or otherwise if the proponent demonstrates to the court that it is more likely than not the expert's scientific, technical, or other specialized knowledge will help the trier of fact to understand the evidence or to determine the fact in issue. The reason I'm objecting on that ground is because this expert witness has, and at least to my knowledge, based off of my review of the CD, he's not a medical doctor, so he's not able to advise us or give conclusions as to how a medical diagnosis could affect the SFSTs. Not just that, I requested the records and written documentation related to this case under the Michigan court rules and they have not provided me with any medical records or medical documentation in regards to injuries that the defendant may have sustained prior to this incident, which may hinder his ability to conduct these SFSTs. So we would be prejudiced. I won't have an opportunity to cross-examine him properly. I don't know what this expert is relying on when he's giving this medical opinion. So on the basis of 702 and 403, as well as potentially a 6.201 discovery violation, I'm objecting. Additionally, I believe that there's a basis under MRE 703 as well. And that is because MRE 703 states, basis of an expert opinion's testimony. An expert may base an opinion on facts or data in the case that the expert has been made aware of or personally observed. The facts or data must be in evidence. And then it continues. But I guess my basis is there's no facts or data in relation to the defendant's medical history on the record. There's nothing in evidence. So it would be barred under that rule as well. So for those reasons, Judge, I wanted to get ahead of this so it didn't come out during the trial. And so Your Honor has an opportunity to make that decision without the jury present. But I do think that he should be barred from being able to testify to anything medical related because one, it's outside of his scope, outside of his training and expertise, as well as the medical rules of evidence appear to me to preclude him from being able to make those.
Okay, so let's take this one by one. So first, Mr. Bulahanis.
Yes.
There's a stipulation regarding SFSTs that your client will be deemed an expert as to that.
Yes, right. That's all.
But for clarification purposes, this is Mr. Corono, correct?
Yeah, correct.
So for clarification purposes, because you're talking, there's a stipulation that Mr. Corrado's an expert as to SFSTs. Now, but let me just ask a question before I give you an opportunity to respond.
Sure.
I know I'm kind of going, out of order a bit.
No worries.
It's my understanding, based on the way that the testimony has gone so far, and based upon, what I've heard as far as proposed, proposed testimony, is that your witness is going to testify as to Mr. Parton's inability to, complete SFSTs based upon some medical issues. Is that the premise?
Your Honor, he's gonna testify to the following. The administration of the standard field sobriety.
Okay, hold on. So my question,
Okay.
is it yes or no? Is he intending to testify as far as to your client's inability to conduct the standard field sobriety test due to a medical condition? Yes or no?
No,
Not at all. That's not any portion of his testimony.
no, but there's a portion of the standard field sobriety test where the officer is required to medically qualify the suspect regarding the administration of the test. So as it relates to the NHTSA and what's contained in NHTSA, the protocols and the rules, he'll be testifying as to that, but he's not gonna give any medical opinions as to, he's not a doctor. There's certain rules that are required under NHTSA, and he'll testify as to those rules, Your Honor. And his substantial expertise in the area, he's been qualified as an expert in Michigan in 26 different courts by 26 different judges. And
Okay,
he's been,
I'm not questioning that portion of it at this point, counsel. So I just wanted to clarify that the stipulation that Mr. Corrado is an expert as the standard field sobriety test, I wanted to be clear that it wasn't going to be addressing your client's medical issues.
yeah, he's not gonna.
It's only as to what the requirements are
Right,
for an officer that's conducting the SFSTs, correct?
correct. Your Honor.
Okay. All right,
That
so,
is what it is. He's been qualified as an expert in the administration and interpretation of the standard field sobriety test by over probably 300 judges nationwide. And
okay, counsel, I'm
okay,
not questioning that part. I'm not questioning that part.
That's-
Because Mr. Mohammed raised an objection regarding potential testimony of a medical nature. So I wanted to clarify if the stipulation for an expert witness, for your client to be deemed an expert as the SFSTs,
right,
and hearing the tenor of some of the testimony, I wanted to clarify that Mr. Corrado wasn't testifying necessarily as to your client's medical issues, but only as to the medical clearance or
right, yeah, that's what.
just in general, what the requirements are for standard field sobriety test roadside.
Yes, sir.
Okay. All right, so does that clarify that portion of that, Mr. Mohammed?
Yes, thank you, Your Honor. As long
Okay.
as there's no testimony that would be elicited in regards to brain trauma, neck fusion surgery and things of that nature. Because again, we don't know whether he truly has that. I haven't had an opportunity to review any records or see anything.
We don't. However, what I'm going to say right now is that if there's a question that's posed, which I'm going to anticipate is going to be posed to the expert witness, right, are potentially hypothetical questions. If somebody has this, how do you clear them, or whatever it may be? So as long as it's not specifically referencing this defendant, well, Mr. Parton has this, how would that affect it, right? That is not a proper question.
Understood.
So just so we're clear, because we don't have any evidence that's been admitted to be reviewed as an exhibit as to your client's medical condition. So Mr. Corrado can't testify as to what Mr. Parton's medical condition is and how it potentially affected the SFSTs, but he can, or at least not deemed an expert in that regard.
Right.
But he can testify and has been stipulated to be an expert as to the administration and interpretation of standard field sobriety tests
Right, and,
in general.
right,
Right.
right.
Now, we don't have any evidence other than your client's testimony as to what any medical diagnoses your client has,
Right, Your Honor, I understand that.
right?
But, yeah, but he can, I think your phrasing, I understand what you're saying,
Okay,
I believe.
And Judge, if I may, even, I can't help but think that even in a hypothetical type of a scenario, it could potentially confuse the jury. And they might think that it's applicable to this case.
Well, Your Honor, first of all, Mr.
well, we're gonna have to take that as it comes, right? I was just indicating that the witness who's been stipulated to be a witness for testimony regarding the administration and interpretation of standard field sobriety tests cannot give a medical opinion about Mr. Parton,
I
all
understand,
right? That medical opinion potentially could, or the inability to provide testimony regarding a medical opinion of Mr. Parton may translate as to not having a direct correlation to his testimony regarding the standard field sobriety tests.
Right.
However, just as Mr. Bulahanis can ask a hypothetical, you can also ask a hypothetical, counsel, right? So we'll have to cross that bridge as we get there. But correct, Mr. Corrado was not going to be admitted as an expert as to Mr. Parton's medical issues or how Mr. Parton's alleged medical issues specifically impacted his standard field sobriety test because he.
no, it's, yeah, I understand that, because there's a clearance required by the officers prior to
Right,
administering.
and obviously your witness can speak to that, can testify to that.
That's exactly.
Correct, okay, all right, so anything else regarding that?
No, thank
I don't believe so, Your Honor.
Okay, and I think that addressed all of your concerns that you raised, Mr. Mohammed, regarding the expert witness, correct?
Yes, thank you, Your Honor.
All right, okay, anything else that we need to address?
So I just want to make sure, Mr. Mohammed is, agreeing that he is an expert witness for purposes of the administration and interpretation of the standard field sobriety test.
Correct, yes.
Correct, yes.
Okay, that's fine.
Yes, okay. As to trying to have any other testimony than in your client, to be qualified as an expert, you'd have to lay a foundation if Mr. Mohammed is not stipulating to that outside the SFSTs. is what I'm
Right, I understand that.
Yes,
Yes, we're stipulating to those foundational questions so that way it also will speed up the process.
Okay.
I've already reviewed his CV and I think he qualifies.
okay, all right, very good. So the court will note that for purposes of the expert witness, that Mr. Corrado has been stipulated to be qualified as an expert witness as it relates to administration and interpretation of the standard field sobriety tests. So what I will also do is I will reiterate that when the jury comes in, so they understand that he's been qualified as an expert witness for that purpose. Okay?
Thank you.
Thank you, Your Honor. Can I talk to the expert witness to make, and indicate your ruling real quick?
Yes, let's go. We'll take a off the record.
2 minutes.
Okay,
Okay, thank you, Your Honor.
thank you. Let's go back on the record in the matter of the state of Michigan versus Shannon Parton 251420A. Both counsel are present, Mr. Parton's present. Mr. Bulahanis, you went out and spoke to your expert witness regarding the limitation, so to speak, or what's been stipulated to, correct?
Yes, Your Honor. We're moving at this time to admit defendant's exhibit A, which is Mr. Corrado's state New York resume.
Okay. And that's a stipulated exhibit as well, counsel?
No,
No.
And Judge, I'm objecting. I don't see what the reason for that is. I've already stipulated to him being an expert.
Because we get an opportunity to publish his resume, whenever you have an expert witness, you know, the jury has a right to know his training and expertise. So, you know, there was a proposed exhibit, there's, you know, it's generally admitted, you know, we could have him testify as to all the different information contained in there. I don't want to spend a lot of time, but if the jurors are listening to the testimony, they have a right to know that he's been qualified in, you know, all these different courts as an expert witness with respect so that they can give him appropriate weight.
Okay, and so your response, Mr. Mohammed?
I strongly object, Judge. I've already stipulated to his position as being an expert. So any kind of a basis is going to prejudice the jury. There's no basis for it other than the fact to just. I don't even know what the basis for it is, to be honest.
The basis for what?
His CV to be admitted. It's a
Mr. Bulahanis stated the reason for the CV because then he can publish, in case the jurors want to review it, where all the times that Mr. Corrado has been qualified as an expert. And then there's also pages as to when he was a guest speaker, instructor experience, skill endorsements. So I don't know if you want to look through the CV and maybe stipulate to certain page numbers. I don't know, the testimonials would be necessary, something that would have to be stipulated.
Take the testimonial
Hold on.
out.
Only one of us can speak at a time for the recording purposes.
I'm sorry.
So, I think instructor experience would be relevant. Skill endorsements could be relevant. Testimonials, I don't find that would be anything that would be beneficial to the jurors, right? As far as, expert witness determination goes. But all of the other basis of the CV is referring to certifications of Mr. Corrado, the courses and conferences that he's presented at, I think it is.
Yes.
As well as his court appearances and qualifications. Many pages of those. Guest speaker, I mean, I guess that doesn't prejudice the jury one way or the other. Instructor experience and skill endorsements. I think all of that is relevant to Mr. Corrado's stipulated level of an expert witness, but the testimonials, the court would find that could be prejudicial as far, and that would not be something that would be admitted nor published to the jury in that regard.
And so, Judge, I guess the basis of the CV is to admit an individual as an expert. So that's usually why, you know, someone would go through that list of what they've done and where they've been published, where they've been admitted as an expert. It's so that the defense attorney or the prosecutor can lay those foundational questions to have that person admitted as an expert. In this specific case, I've already stipulated based on the review, because I don't think it's necessary to go through an 80-page CV to make that determination. I've agreed to it already. So any admission of that is, number one, cumulative. Number two, could potentially prejudice the jury and think just because he's on the defense's side, maybe they're correct. I don't know what's going to go into the jury's head, but what I do know is that the basis of that CV is to admit someone as an expert, and we've already stipulated to that. That's number one. And number two, at this point in time, it's no longer relevant whether he's been an expert in a case in California and here in Michigan. At that point, it's no longer relevant. The purpose of that CV is for him to be qualified as an expert. We've already agreed to that. So that need no longer exists. That's the people's position.
Your response, Mr. Bulahanis?
Your Honor, my initial response, I use that plus the jury instructions say a stipulation between the attorneys that they don't have to follow there's a jury instruction that says they may consider as, true, but they don't have to follow that. They need to know what degree of expertise he has, how many years he's been doing this, to give him, they're weighing his credibility. And so just by saying that he's stipulating that he's just an expert, there's no harm, there's no prejudice to my client. My client's the one that is here on trial. There's no prejudice to the prosecutor showing it's true and accurate. He's stipulating that he's reviewed it and it's true and accurate. There's no reason why the jury shouldn't have that information. It's to further educate him on and give, so that they can give him the appropriate level of proof, the appropriate level of weight that they deem fit based on his CV. And the court's already indicated as well initially when you rule that, his experience as an officer, his qualifications as an expert witness, all these things are relevant to the standard, the admission of, these all go to the admission and interpretation of the standard field sobriety test. I will take out the testimonials as indicated by the court. That's not a problem.
May I respond?
You already have?
I will rule whether he can respond or not.
Okay.
There's been a lot of responses on both sides. At the end of the day, Mr. Mohammed, I'll let you respond one more time.
Thank you, Your Honor. So I'll start where defense was starting in his argument, which was the stipulation. At the time the court made that finding here on this court record, there was no objection to the stipulation. He even went up, he even asked for a break to step out and inform his expert of the court's finding or order that there's a stipulation in regards to the expert being qualified as an expert. That's number one. Number two, I did review it, and that's why I've stipulated to it, and that's why I believe at this point there's no basis for it. The purpose of that CV and his history and all the court cases is because he's qualifying him as an expert, so the need no longer exists. So any questions that would just focus on what his history is as far as being qualified as an expert no longer is needed, because I've already stipulated and the court's already ruled that there's a stipulation and it's coming in regards to his expert being qualified as an expert. So that need no longer exists, which is why I believe allowing it at this point would be, number one, irrelevant, and number two, would potentially violate the balancing test.
Okay, well, here's what the court's going to rule. The court's going to rule that number one, Mr. Corrado has been stipulated to as an expert for purposes of the administration and interpretation of the standard field sobriety test. Further, there has been a proposed exhibit by the defense as to Mr. Corrado's expert witness and what makes him an expert witness, whether it's for this court to go through and listen to, 89 pages as to why Mr. Corrado should be qualified as an expert, or there's been a stipulation. The court will further state that having this proposed exhibit admitted and published, in the event the jury wanted to review how long back Mr. Corrado's expert witness designation goes, they could certainly review that. Mr. Bulahanis also, if this were to not be admitted, could go through all 89 pages and ask questions about it. That doesn't prohibit that, right? The court does not find that it's prejudicial, nor cumulative, nor otherwise to admit this proposed exhibit up through page 84. Pages 85 to 89 are to be removed because the court does find that could be prejudicial to the jury, hearing testimonials of individuals or reading testimonials of individuals that they don't have any basis as to what that testimonial was regarding or otherwise. So pages 85 through 89 must be removed. That is not going to be admitted for purposes of the exhibit.
Your Honor, just a brief thing that I want to highlight. So for example, on page 76, there, it talks about juvenile law and things of that nature. On page 77, it talks about legal assistance. On page, and then there's so many pages that I think include things that are just not relevant to this case. So at this point, I would object to its admission, and I would ask that the court, ask defense counsel or instruct defense counsel to lay foundational questions to admitting each page at that point.
I'm not doing that. No, I'm not, your objection's noted. I've made my ruling. If it's not relevant to the case at bar as to whether or not, I think this is what this is referring to is how many times he's testified on certain types of law. And this is just part of his curriculum vitae. If the jury decides they want to look at this, then they can disregard that as it's not relevant to these proceedings. However, we're not going through 84 pages, page by page, to determine which page is going to be admitted and which is not. The court notes your objection, counsel. The court's already made its ruling. The court's going to order pages 85 to 89 are to be removed. And as far as the exhibit. So the defense exhibit for the expert witness, the proposed exhibit for expert witness, Tony Corrado is admitted from the cover page through page 84.
Thank you, Your Honor.
So Autumn, do you have the exhibit there? Okay, so then we just need to remove page 85 through 89 out of that, please. And the jury may not even ask to review it. I don't know. And then, Mr. Muhammad, your exhibits were numbers, correct?
Yes.
Okay, so this is defense exhibit A. Is this your first exhibit?
Yes, sir.
Right, so defense exhibit A is admitted and published from the cover page through page 84.
Thank you.
Okay, anything else that we need to address before we bring in the jury?
No,
Okay.
not for the pages.
No, Your Honor.
All right. All right, can you please have staff bring in the jury?
Do you want to get the expert witness first?
No, I'll have Mark bring them in, but after the jury comes in.
Okay.
All rise for the jury. You may be seated. All right, good morning to you all. I again appreciate your patience. I did have an in custody to handle, and then I had a matter I needed to handle as well on a case that was disqualified from another court and was sent over this way. And then we had to handle some preliminary matters here before we called all of you in. So I hope that all of you have a good 2 weeks of rest and you enjoyed the donuts and the coffee in there and any other snacks. And then we will proceed. So we paused at defense was getting ready to call their next witness. The court will have, if you can, Mark, if you can grab Mr. Corrado, please. And so defense, you may call your next witness, please.
Your Honor, defense calls Tony Corrado to the stand.
Yes, my name's Tony Corrado, D-O-N-Y. Last name is spelled C-O-R-R-O-T-O.
Okay, thank you. All right, and you may proceed.
Your Honor, may we approach the,
Oh, I'm so very sorry. What, I'm sorry?
may we approach the bench for just a moment?
Okay. So off the record. First will note, as I reading the jury instructions beforehand, that there sometimes may be stipulations. And so in this matter, Mr. Corrado has been stipulated to, as an expert in the administration and interpretation of standard field sobriety tests. Okay, so the purpose of that is so that the foundational questions that would be necessary per the rules of evidence to establish a witness as an expert, does not have to be made. The prosecution and the defense are both stipulating that Mr. Corrado is an expert for that purpose. Okay. Are the people satisfied with that statement?
Yes, Your Honor.
Defense?
Yes, sir.
All right, thank you. You may proceed.
Thank you so much. Mr. Corrado, you're a expert witness in what area?
Objection. That's the leading question, Your Honor.
There's been a stipulation that he's an expert witness.
Right. Yes, sir.
But it still doesn't allow the attorney to ask leading questions on direct examination.
What's the leading question part, counsel?
He's saying you're an expert, correct? I mean, or essentially,
We've stipulated
He asked-
that.
the question was, you're an expert witness in which area? Wasn't that the question? Was that the question?
Yes, that's the question.
Right, the court's going to overrule the objection.
I'm an expert in the administration and interpretation of DUI detection and standardized field sobriety testing.
Okay. And so, did you have an opportunity to review, the police report and the, body cam in this particular case?
Yes, I did by Officer Harris from the Wyandotte Police Department. Yes, I did.
Okay. And, with respect particularly to the administration of the standard field sobriety test made by Officer Harris, which,
Your Honor, I'm going to object. It looks like the witness is looking down and reading at something, or maybe he's just looking down.
I'm just looking now. I'm
But
listening.
I think that was a legal objection.
First of all, we're not doing this today, counsel, between both of you. Second of all, I've already instructed the witness when he first came up. I instructed not to review any documents that he may have in the folder that he brought up with him. I've already instructed him on that. He's not doing that. In fact, what we can do, Mr. Corrado, if you wouldn't mind just putting that, perfect. There we go. You may proceed.
Thank you.
The court's going to overrule the objection.
Okay. Thank you, Aaron. So let's start over. You had the opportunity to review the body cam worn by Officer Harris with respect to this case.
I did.
Okay. And, did you observe the administration of any, standardized field sobriety tests?
Yes, I observed the administration of the horizontal gaze nystagmus and the walk and turn evaluation.
Okay. And, in your, expert opinion, did Officer Harris, administer the horizontal gaze nystagmus test, pursuant to the requirements of NHTSA?
As per science through NHTSA, and that NHTSA is actually the National Highway Traffic Safety Administration for the acronym for the NHTSA. That accompanied with the International Association of Chiefs of Police. Those are the two entities for standardized field sobriety testing. They write the manuals for the nation. To answer your question, no. Officer Harris's administration and interpretation of the field sobriety test, in my opinion, the HDN was incomplete. In my opinion.
Can you tell the jury why?
Yes. Prior to, in totality of a horizontal gaze nystagmus test, there's supposed to be a certain amount of passes that the officer is supposed to comply with and go back and forth across, looking for different movements of the eyes. The first part of the evaluation is incomplete, was never assessed, which is the medical portion of the evaluation. It was never done by Officer Harris. He didn't do it.
Okay, and so, with respect to the passes, done by Officer Harris, can you be more specific as to what the issue was?
Yes. The first part of horizontal gaze nystagmus, the officer needs to make sure this person is a candidate. They're a candidate to do horizontal gaze nystagmus, which is the field sobriety test, You want to make sure this person is a candidate to do the rest of the field sobriety test, that make sure they can actually do it and they're medically qualified to do so. On the horizontal gaze nystagmus test, when the officer is holding the end of his finger or stimulus up in front of the face of the person, the first 4 passes I should see as an expert of viewing the video or anybody viewing the video is he's supposed to be making, first of all, 4 passes very slowly without stopping, going approximately 30 degrees per second, 2 seconds out, 2 seconds in, not stopping at either end, at either point. That officer needs to make sure that, number one, both eyes have the ability, ocular, to look left and look right. I muscle health. I got to be able to look to the right and look to the left. So I need to establish that. That wasn't established in this case. I need to know whether or not both eyes, looking at the eyes, looking at the pupil, smallest part of the eye, are the same size and value. I want to make sure one's not large and the other one's not small. If I see that, this is not a medical candidate for this actual test. If I see the eyes are shaking while I'm just looking at them and they're shaking like that, that's called resting nystagmus. If I see that, I cannot do this test. Those 4 passes are so important to the rest of field sobriety testing. If you don't complete those, actually the rest of field sobriety is null and void, in my opinion, because you have to make sure a person is a candidate to move on before you go further.
And with respect to a little bit more detail, when the officer does the pass for nystagmus, and is there a requisite time that he's supposed to hold the stimulus prior to moving on?
Yes.
And what is that?
Approximately 4 seconds at endpoint, all the way to the end.
Okay, and did you, when you viewed the video, was that accomplished in this?
No, that was not done correct.
Okay. Okay. Can you inform the jury what are all the steps required as far as how far away is the officer supposed to hold the stimulus and et cetera?
Sure. Now, during the horizontal gaze nystagmus test, you have a person standing in front of you with their feet together, arms to their side, not to do anything until you tell them to, and to make sure they understand that. At that point, an officer presents something for them to focus on. It could be the end of their finger, it could be a lighted instrument, the end of an ink pen, end of the tip of a pencil, something where they can focus on while the officer is giving a set of instructions. They're to stand in front of you, and then the officer has a set of standardized verbal instructions. I'm going to check your eyes. I want you to focus on the stimulus, continue to follow the stimulus until I tell you to stop. Okay, keep your head still. I want you to follow it the entire time until I tell you to stop. Okay, and once he starts that, and that's when I talk about whether or not this is a medical candidate, the first 4 passes is called equal tracking. Like I said, number 1, I want to know whether both eyes are following at the same time. And then once I establish that, you talked about the first scoreable clue of horizontal gaze nystagmus. Its movement is called lack of smooth pursuit. Officer Harris did not do that correctly. That's when the next 4 passes he administered, he's going back and forth again. He's pausing at endpoint. This is supposed to be a slow, continuous movement and not stopping at the end. It should be a smooth, he's stopping at the end, which could make the eyes jerk. So that's what makes that invalid. When we get to the next stage of horizontal gaze nystagmus, it's called distinct and sustained nystagmus at maximum deviation. That's what we're referring to. That's when you bring the stimulus all the way out to approximately 60 degrees. 60 degrees is when there's no more white in the corner of your eye. And you need to hold that stimulus for a minimum of 4 seconds. Why is it 4 seconds? Because almost everybody in this courtroom will have involuntary jerking of the eye. If I brought your eyeball out to 60 degrees, because there's an unnatural movement, we're not used to doing that, if you think about it. We're sitting here. You okay?
Yes.
No, he's about to jump on.
I don't, sir, I'll ask.
Okay.
You can continue with your testimony unless there's an objection, please.
Now after the part of the sustained nystagmus, what occurs next?
Okay. After distinct and sustained maximum deviation, like I said, The eyes have to be, it has to be distinct, sustained for a minimum of 4 seconds or greater.
And what does that mean? Can you tell the jury, please?
That means that's a definite clue that I saw this in the eye. If you shortcome that and start to see a jerk and then go back the other way, we all have that. So it's not a valid clue. So his 4 passes, he shortcome all 4 passes of that. So what's that?
Judge, I'm gonna object to the we have that. That sounds like speculation. He doesn't know what one person from the next has. Maybe one person's eye may jerk, maybe another's doesn't. So I'm gonna object to the we all have that portion. Also, he's not a medical doctor to tell us whether or not it's normal for eyes to do that.
Okay, your response, Mr. Bulahanis.
Your Honor, I think I can rephrase that question, but I can ask him another question if he can tell us what the basis of that answer it was based on.
Okay, well,
I can connect.
tell me what you're going to do next. Your response to the objection, please.
Your Honor, I don't think that the objection is relevant to the administration of the HGN test.
Okay, so what the court's going to do is the court's going to sustain the objection in part, overrule it in part. Mr. Corrado has been stipulated to be an expert in the area of administration and interpretation of standard field sobriety tests. So as the testimony relates to Mr. Corrado's experience as an expert, the court's going to permit that. The testimony of we all have needs to be clarified, counsel. So please, if that's happening, that needs to be clarified.
Yes, thank you. I'll move on to another question.
Well, first clarify that.
Okay, can you clarify your statement that we all have? What do you?
Yes. In the NHTSA writings and the actual manual itself, NHTSA is aware of distinct and sustained nystagmus can be present for a second or two to individuals. For this to be a distinct and validated clue, it has to be distinct and sustained for a minimum of 4 seconds or greater.
Okay, thank you. Thank you for clarifying.
Yes.
Okay. Now with the balance of the horizontal gaze nystagmus test, did you notice anything else regarding that with the administration by Officer Harris?
Other than the fact it was not administered correctly, I observed no visible swaying, either front to back, side to side, or circular during the administration when he stand with his feet together, arms at his sides.
And is that a clue?
It's not a clue, it's a visual observation I look for as far as, alcohol and drugs affect individuals differently. When it starts to impair the body, sometimes you start seeing swaying. I didn't see any, Mr. Parton.
Okay. Now, with respect to the walk and turn test, do you observe that field sobriety test administered by Officer Harris?
I did.
Okay, and did, in your opinion, based on NHTSA, did Officer Harris properly administer that test?
Yes, and he properly administered it. However, the interpretation of the clues were improper. He kind of marked things that I didn't see.
Okay.
As far as actually in his police report.
Can we be more specific? So this is based on your review of the police report?
Review of the police report, yes.
Okay, and so please indicate for the jury what indications were not.
Judge, I'm going to object. That's hearsay. What's in the police report is hearsay.
I'm not asking to indicate what's in the police report, Your Honor. I'm asking what he saw with reference to the walk and turn test.
No, if I recall, Your Honor, may I respond?
You may respond.
What I heard him say, and I may be incorrect, but I thought he asked him what he saw in the police report that was incorrect. And so that is hearsay. What's in the police report is hearsay. He had an opportunity to bring that up with the officer when he was on the stand. It was his police report. this individual is not the correct individual to ask that question. If I heard the question correct.
I'll rephrase the question, Your Honor.
That's the question I heard, and the court will sustain the objection.
Thanks.
So you may ask another question, counsel.
Yeah, did you watch the body cam
I watched Bodycam.
with respect to the walk and turn test?
Yes.
Okay. Can you restrict your testimony to the body cam, your visual observation of the body cam?
Sure.
Okay. Based on that, did Officer Harris, administer the walk and turn test correct?
The administration,
Objection asked and answered. Earlier, Your Honor, he asked the same exact question. He said yes in regards to one portion, but his interpretation of that test, he said disagreed with.
Counsel, that was as he relied on the police report. You objected to the police report being utilized as hearsay. I sustained the objection. So now the question is along the lines of upon review of the body camera. So now this question is based upon this witness's observation of the walk and turn test from the body worn camera. So I'm going to overrule the objection because now the question, this line of questioning is as it relates to the body worn camera.
Yes, Your Honor, but prior to the question about what was in the police report, he did ask him if he observed.
I know that, counsel. And then the question was, were you relying upon the police report? The testimony was yes. You objected to that. I sustained it. So now we're moving on to the body camera. This question is as it relates to the body camera. The court's going to overrule the objection. You may proceed.
You remember the question?
I think.
Okay, could you please state your answer to the question?
Can you repeat the question?
Yeah. Based on your view of the body camera of Officer Harris, did Officer Harris correctly administer the walk and turn test in this case?
Can I refer to my notes for 2 seconds? Just
If it refreshes your memory.
refresh my.
The question was, will it refresh your recollection? Any objection? Any objection, Mr. Mohammed? Hold on, sir. Don't review this yet.
Yeah, no objection.
Okay. All right. You may proceed.
Does that refresh your recollection?
Yeah.
Okay, are you able to answer the question
Yes.
based on your refreshed recollection? Please answer.
Okay. During the administration of the officer's administration of the walk and turn, part of the instructions that were missing was, well, not missing, but the officer actually stopped walking during the demonstration. He stopped walking twice. You're supposed to demonstrate 3 heel-to-toe steps. The officer stopped walking, did the turn, stopped walking again. And during his verbal instructions, he tells him not to stop walking. So we learned by watching things. So if the officer stops walking, it creates the difficult for the person to actually do the evaluation.
Okay, and then, is there anything else you noted about the walk and turn test as given by the officer?
The officer gave complete instructions for the actual test itself.
I'm sorry, gave complete or incomplete?
Complete.
Okay.
Okay, okay, and then, with respect to the one-leg stand, did you observe the officer give any instructions to the one-leg stand?
The one-leg stand was not done in this case.
Okay, and did the officer indicate why?
Objection calls for hearsay.
I'll withdraw the question.
All right. Objection sustained.
Okay. Now, does NHTSA provide for alternate testing besides the standard field sobriety test?
Yes, when someone is not a medical candidate or they're just can't do the field sobriety evaluations or having difficulty, they have alternate type field sobriety evaluations taught by NHTSA. Would you like to know what they are?
What on?
Okay, one of them would be called a finger dexterity.
Well, Judge, I'm gonna object. I don't see the relevance.
Well, I can tie that together, Your Honor. The relevance is oh, I'm sorry.
Your objection to the relevance of the question that was just asked?
Yes, what the other tests that were not associated with this case are.
Okay, and so you're going to tie that in as far as being relevant in what way, counsel?
Your Honor, the officer testified that, he's been trained with the NHTSA manual, that he was unaware of any non-standardized field sobriety tests, and that's all part of the testing for the.
Okay, the court will overrule the objection at this point. The court will give you some leeway to tie in the relevancy.
There are non-standardized field sobriety tests when administered correctly will divide a person's attention, a mental and physical task at the same time, and give you the same effect or benefit for like a walk and turn one leg stand evaluation. One of them would be what's called a finger dexterity test. It's simply using left or right hand, using your thumb and index finger to start, or the pinky, start 1, 2, 3, 4, 4, 3, 2, 1. And that's repeated several times. That can be done when a person is pulling up to a road. Oh, you don't have roadblocks in Michigan. I'm sorry. I take that back. I just strike that. That is a field sobriety test that can be done while in a car or right in front. Second one would be alphabet test. Start with the letter C and with Q. Anything to stimulate information processing, short-term memory. That's the second one. Alphabet test. Alphabet counting test. Start with number 67 and with 54. Anything to stimulate, starting and stopping, divided attention. Those are three that NHTSA provides.
And those are, in the event that a person's not medically qualified or isn't able to do the standard field sobriety test?
Yes.
Okay. And so that should be at an officer's disposal as well?
Yes.
Okay.
Objection, Judge. He's not qualified to answer that question. What should be in an officer's disposal in the state of Michigan as a police officer? That's not his determination to make. What they should be trained on and what they should have in their arsenal as far as being able to detect impairment. That's for police departments and the state legislature to make that decision on, not for this witness.
Your Honor, I just need to ask that's all part of the standard field sobriety testing. So,
Also, you're testifying right
okay,
now.
I'm
The
sorry.
objection was that this witness is not qualified to testify as to the answer to the question you asked.
He is qualified to answer that, Your Honor, because that's all part of the standardized field sobriety testing. It goes along with the testing that the officers receive when they get the standard field sobriety testing. That's all part of it. That's what he testified to.
The objection was that this witness testified that the officer, that they have it at their disposal to use.
Yes, one of the things.
And that's what the officers in Michigan are required to do.
I'll rephrase the question.
All right, so the court's going to sustain the objection in part and overrule it in part. You may clarify, counsel.
Thank you, Your Honor.
Thank you so much. So when an officer is being tested for the standard field sobriety test through these are courses they take, correct?
Yes, it's all part of the curriculum.
Okay, and as part of the standard field sobriety test, are any other tests taught to the officers at that time?
No.
Okay. Okay. And so, are any non-standardized field sobriety tests taught at that time?
That's the ones we're referring to, the non-standard. The standardized field sobriety tests are the horizontal gaze and stack, that's the walk and turn and one leg stand.
Yeah, so what I'm asking is, when they teach you the standardized field sobriety test, does that also provide information regarding the non-standardized field sobriety test at that time?
They do.
Okay, that's what my question, I'm sorry, it was not fully asked. So if an officer, you've taken that test, correct?
The field sobriety? Yes.
And you're an instructor.
I'm an instructor in the program.
Okay, and so, so when, any officer is taking the standardized field sobriety testing, they're also instructed to ask them the non-standardized field.
Yeah.
Okay, thank you. That's all I have.
All right, thank you. And Mr. Mohammed.
Thank you. Good afternoon, or good morning, sir.
Good morning, sir.
My first question is, I think you indicated earlier that you had tested, and correct me if I'm wrong, somewhere in the range of like 24 cases here in Michigan.
Yes, I have.
And how many cases exactly do you recall here in Michigan?
A total of 49 appearances in the state of Michigan.
In a criminal case?
Yeah, all criminal cases.
And of those,
Hold on, first of all,
Thank
sir,
Um,
I will control the tenor of this court. So, if you are not done, I was just getting ready to instruct the attorney to wait until you've completed the answer before he moves on to the next question. So as a reminder, counsel, let the witness finish the question before you move on to the next one.
well, Your Honor, my question was very straightforward, and I was asking the number of cases. He answered it. Any additional information was not asked. So
No, you asked, do you know the specific number of cases?
he said
So-
49.
49 appearances. So then he had to qualify that. So when I make a statement, counsel, it's not an invitation for an argument. You may continue with your testimony, Mr. Corrado.
Out of the 49, I believe, I'm not looking at my notes, around 26 or 27 times, I qualify as an expert in the state of Michigan. 27 times, I qualified in the administration, interpretation of DUI detection, standardized field sobriety testing. I qualify as a drug recognition expert and instructor. I qualified in the theory and science of evidential breath alcohol testing. I've been as far as Escanaba twice. I've been far south as Adrian.
Thank you, sir. And of those 20 plus times that you've been qualified as an expert here in Michigan, how many times were they on behalf of the defense?
All of them.
And were you paid?
Yes, so I have to be paid to do my job, sir.
Have you been paid to be here today?
I have to be paid to be here today.
So is the answer yes or no?
Yes, the answer is yes, sir.
You were paid by who?
Mr. Parton,
And who hired you?
Mr. Parton.
How much were you paid to be here today?
For today, I'm not charging anything today because this is my third appearance.
And how did you come here?
I drove in my car from Georgia 10 hours last night.
And you indicated you've been here 3 times?
Yes, I have.
How about the first time?
The first time I sat out there for 8 hours while you're picking up
That
your
wasn't my question. How did you arrive here in the state of Michigan the first time?
by airplane.
And who paid for that flight?
Mr. Parton paid for the flight.
And how about the second time?
Mr. Parton paid for my flight the second time.
How about the return flights?
You mean to get me here today?
No. So you paid, the flight was to get you here in the state of Michigan, correct? The first 2 times.
Yes,
I'm assuming you returned back to Georgia.
I did. Yeah, they're around.
How did you?
Round trip.
So did you return by plane?
Yes.
Okay. And what is the price to hire you? What was Mr. Parton charged to hire you?
I charge a $3,500 flat fee to appear on Mr. Parton's behalf. That includes giving my opinion today. That includes my travel expenses.
How much was Mr. Parton charged in the totality of this case for you to be here today?
It'd be probably 3,500, about 6,200 total.
Okay, sir, you understand, you're testifying under oath, correct?
Yes, I have 2 different value amounts from the first trip to the second amount.
Okay, but
I didn't charge him as much the second.
Hold on, sir.
So,
Just the answer was yeah. You answered yes. The attorney has another question.
So you can understand why I'm asking the question. It sounds like there's 2 different values. So what is the total amount of money that Mr. Parton has spent to hire you and have you here up to today's date?
6,200.
Was the $6,200 you've been paid so far paid in one lump sum? Is it hourly?
Objection, relevance.
What's the relevance to how the payment is?
Goes to
paid?
bias, Your Honor. If he's being charged hourly, it could suggest one thing. If it's one lump sum, it could be a different.
Okay, the court will give you a little bit of leeway in that regard. The objection's overruled.
I charge a flat fee. And I don't charge hourly for this case.
So my question is, in this specific case,
Yes, sir.
were you paid the $6,200 in one lump sum, or was it broken up into different payments?
It was broken up. I didn't know I had to come back the second time.
Earlier, on my previous question, you made it seem that there was just one flat fee. I think you used
That's
the
for
word.
here, that's for appearance.
Sir, Mr. Corrado, please let the attorney finish the question before you respond.
Sir, I believe you stated the word flat fee, and so I'm just trying to decipher exactly what was paid in this case and how it was paid.
Sure.
Thank you. Did the defendant pay flat fee of $6,200, or was it broken up into different payments?
It was broken up.
Why?
Because my first appearance here was back in February. I charged $3,500 for that. And then we found out I had to come back. The case got reset again. So I charged my travel and I charged an appearance fee and I had to do a report, which you read for this case. So that's why we have an odd amount. It's not 35 and 35, it's 35 and 3,200 because I had to charge to do a report in this case. And now I'm back a third time and I didn't charge to come back. I did that on my own dime.
But you've been paid so far as of today's date, $6,200.
That's correct.
Okay. And do you do this for a living?
I do.
And what is that exactly? Is you're hired to testify in court hearings as an expert?
No, I'm an impaired driving consultant. I analyze police officer cases involving DUI cases all over the country.
Where do you-
Court. And I teach via seminars.
Well, sir, we're not getting into that. In regards to cases, criminal cases that you're hired to testify and give your opinion on as an expert, are majority of the individuals that hire you defendants?
Yes.
So would you say it's safe to say you're more towards one party rather than being a neutral party?
I would say 98% of my work is criminal defense work and 2% would be prosecution type on civil cases.
So my question is, would you say majority of your cases is more favorable to one party?
It's not favorable. I do an investigation and on a non-biased investigation on a case and come up with an answer of whether or not it was a valid arrest.
So
That's my job.
it's not favorable to a position?
It would be favorable to him if I found out his arrest was invalid, or it would be favorable to Officer Harris if he did his job correctly.
Sir, it's a yes or no question.
Repeat the question, please.
Is your determination usually favorable to a specific party?
Yes, that's my job. Absolutely.
And you indicated 98% of your clientele.
No, I said 98% of my work is criminal defense.
Sir, please let the prosecutor finish the question before you respond.
Yes, Judge.
98% is towards criminal defense, correct?
Yes, sir.
And you understand the difference between prosecution and the defense?
Yes,
And you understand the defense is a specific party, correct?
yes.
So I'll say my question one more time. When you testify criminal cases as an expert, you say that your position is usually favorable to a specific party.
Objection asked and answered several.
Please stand up when you're addressing the court counsel.
Sorry. Objection asked and answered is indicated the percentage.
Judge, he's not answered the question.
100% did answer the question. He says it's not biased to one party or another. He provides a non-biased investigation to determine what the evidence shows as to who's doing, if somebody's doing their job correctly, not correctly. That was his answer. The court will sustain the objection. Next question.
Understood. Sir, are you medically trained as a physician?
I am not.
How about as a nurse?
I'm not a nurse.
Do you have any certifications from a medical college or a bachelor's in that field of work?
Objection irrelevant.
Okay, objection is relevance. Mr. Mohammed, your response.
Judge, it's very relevant. He testified in regards to the pupil size and things of that nature on direct examination. My following questions is going to go dive into that stuff.
Okay, so the court's going to sustain the objection as to that line of questioning not being relevant. If you want to ask a question as to how he knows that, then you can certainly do that. Potentially at a later point, that line of questioning may be relevant, but at this particular point, it's not relevant.
Sir, you reviewed the footage in this case, correct?
Yes.
And I think on direct examination, you testified in regards to the pupil and the size of it, correct?
Yes.
And you saw the defendant's eyes, I'm assuming, in the footage, correct?
The movement of the eyes, yes.
So you saw his eyes to make that determination, correct?
What determination, sir?
Did you see his eyes in the video?
I did see his eyes, yes.
And did you analyze those eyes when you were basing your testimony on? When you had,
I analyzed his eyes. If you're referring to pupils, no, you can't see that from a body cam.
because earlier you testified to pupil
I
size.
did. What I testified earlier is equal pupil size is a medical qualification tool prior to administration of horizontal engagement statements.
Thank you.
Sir, counsel, let him finish. Continue, sir.
Prior to administration, you want to be ensure both eyes are equal in value. Both sides are, if you got a 0.5 millimeter difference between one pupil and the other, that is not a candidate to do horizontal engagement statements. And I stated earlier, Officer Harris didn't check for this.
All right, thank you. Next question.
How do you know that?
How do I know that? Because I counted the amount of passes.
How do you know that he didn't check his eyes?
Mr. Mohammed, he's answering the question. Let him answer the question.
I counted the amount of passes that I observed on the body cam. By counting the passes, I can tell which part of HGN he's doing, which part of HGN he didn't do, which part of HGN he is doing correctly, which part he's not doing correctly. That's my analyzation, sir.
Okay, you indicated that you had analyzed the defendant's eyes, correct?
By watching the officer doing HGN on the video, I could see the movement of the eyes. Just a little bit, but I can tell,
You said just a little bit?
I'm sorry?
You said just a little bit?
Just barely, you can see.
Barely?
Mr. Mohammed, let him finish the answer before you go with the next question. My court recorder is having a horrible record because there's interruptions and it's not picking up all of the words. That's why we have to do that.
Understood.
You may continue with your answer, Mr. Corrado.
I forget where I was, Judge.
The question was, you were testifying as far as what you viewed on the video, as far as the eyes of Mr. Parton.
I observed the officer moving the stimulus and the eyes following the stimulus.
Thank you. Earlier you indicated barely. Can you clarify?
No, I can't.
Are you
Because
refusing?
you were throwing a bunch of.
Sir, you answered no, you can't. Next question.
Next question.
Yes, sir, I just said next question. I don't need you to say that as well.
Sorry, Judge.
Sir, just so you understand, I asked the questions, not you.
Yes, I just said that, counsel. Next question.
Sir, can you clarify what you meant by barely? Just a few moments ago.
I can't.
I'm sorry?
I can't.
Why not?
I don't know. Because you were interrupting my speech and I was trying to throw words in there and I got kind of interchanged a little bit because you're interrupting me. So I couldn't make a complete sentence. I apologize.
So earlier when you testified barely, is it your testimony now that you didn't mean to say that word?
I didn't mean to say the word barely. Okay, I apologize.
Is that your testimony now?
Yes, strike the word barely out of it. Please.
Sir, I don't strike anything. And so, did you get a clear look at his eyes, the defendant?
Explain.
Excuse me, are you asking the attorney to clarify?
Yes.
Then you can ask him to clarify his question.
Can you clarify that question, Mr. Mohammed?
Yes, sir. In the video, did you observe the defendant's eyes clearly?
Yes, as they were following Officer Harris' stimulus during the administration of HDN.
So yes, and just so I can confirm what you're saying. Yes, you observed the defendant's eyes clearly in the video?
As they were following the stimulus, Officer Harris was moving back and forth.
So it's a yes or no question.
Mr. Mohammed, he's clarifying as to when he answers yes. Next question.
Understood. And in those moments that you could see the defendant's eyes clearly, because there was moments where you could see him clearly, correct?
When they stopped, you can just see an eyeball stop, yes.
Okay, so you can see his eyeball?
You can see an eyeball, yes, part of the eye, yes. I wouldn't say it's clear, but you can see an eyeball.
Okay. Can you tell me what color his eyes are?
No, not from the body cams, no. You can.
Well, earlier on cross-examination, you indicated that you could see his eyes clearly at one specific point. So I guess my question is, were you not paying attention to that level of detail in regards to his eyes?
What do you mean? I don't understand, sir.
You indicated that at some point you could see his eyes clearly, correct?
Objection, mischaracterization of the testimony, Your Honor. The testimony was he could see his eyes, I believe clearly, as he was administering the passes.
That's correct. All right, the court's going to sustain the objection.
So, sir, at some point you saw the defendant's eyes clearly. At some point during the testing.
Objection asked and answered.
Well, Judge, then he has to answer the question.
He did. He's answered it a number of times. The question you asked was, well, one of the times you asked was whether or not Mr. Corrado didn't pay attention to the color of the eye because that wasn't something he was focused on. That was one of your questions that you had asked.
Yes.
Right. Okay. So the answer to that question, Mr. Corrado?
Which one, Judge? I'm sorry.
Did you not pay attention? Did you not see the color of Mr. Parton's eyes because you didn't pay attention to that?
Correct. That was
Okay.
not my assessment.
All right. So the answer is yes. So that answers that question. Next question, please.
My next question is, why did you not pay attention to that level of detail in regards to his eyes?
Because that's the officer's job. An officer's job standing in front of someone has a clear view, unobstructed view of a person's pupils that are really, really in the center of your eyes. They're very, very difficult to ascertain on a body camera. You can't see them, or even a car camera. Only the officer can make that medical determination because they're standing right in front of you, whether both eyes are equal in value. As a person, myself, watching a video, you can't make that decision.
So is it fair that there's certain things you might not see on a body-worn camera? Is that fair?
Like what?
Well, you just indicated right now that you can't, certain things you're not going to be able to see on the body-worn camera. You just stated that in your response or something.
That's true. You're not going to be able
Hold
to
on,
see.
sir, Mr. Corrado, please let the question finish completely before you start to respond. Okay. Mr. Mohammed.
Thank you. So, sir, you indicated, or something along the lines of, you're not going to be able to see things of that nature on the body-worn camera. Some things you're gonna miss. Is that fair? You can't see everything on the body-worn camera. Is that fair?
In relation to,
Seeing the eyes on the body-worn camera, you're not gonna see every detail. Some things just might not be clear enough.
correct, there's a lot of times you cannot see nystagmus, whether it's present or not.
And so, is it your assessment that or based on your opinion, you're an expert, right? You've done this a number of times. That being in person, sometimes you can see things with a little more detail than you will on a body worn camera.
Absolutely.
Thank you. And so in this specific case, it's possible that you could see something on the body, you could miss something on the body worn camera, but it doesn't mean that if you were in person, you wouldn't have seen that thing. Is that fair?
You really confused me, but I'll say that's fair. Already.
Why do you just
You're just
agree?
refraining your questions. You're just.
Well, I can just let me know and I can rephrase my question.
That'll be fine.
Again, only one of you can speak at a time for the record, please. Stop, just wait till the question is finished. And it's not, we're not engaging in a conversation, casual conversation. It's question and answer, please. Because our record is not catching all of the words.
So, sir, in regards to body worn cameras and physical observations, based on your experience, is it fair to say that you can see things with more details when you're in person than on a body worn camera?
Yes.
It's possible that it happened in this case. Fair? Is it possible that in this case,
Objection calls for speculation.
Judge, I mean,
Response?
he just answered the question not in relation to this case, the question before. And so now I'm asking if it's possible in this case, even though he's already testified that it is possible. But now when I relate it to this specific case, there's an objection and he's not wanting to answer the question.
Objection to the characterization of the witness doesn't want to answer the question. We're doing proper objections here, and the witness waits for the judge's ruling on the questions before he would answer. That's the proper procedure, actually.
The court's going to overrule the objection at this point to allow the witness to testify as to that specific question.
Thank you.
If he's able to.
Thank you. Go ahead, sir.
Repeat the question, please.
Is it possible that previously you agreed that in person you can see things with more detail and it's possible to have been missed on the body worn camera, correct? In general.
Sure.
And so in this specific case, it's possible that could have happened as well, correct?
Not with the administration based in. No.
Why is it possible in cases in general, but in this specific case, it's not possible?
Here's why it's not possible, okay? The proper administration of ACN, I should be viewing 16 passes on that body cam.
Sir, but that wasn't my question.
I'm not finished.
He's not finished, counsel.
With
You
12
asked,
passes-
excuse me.
I'm sorry.
You asked a question, you asked why. He's testifying as to why. Continue, Mr. Corrado.
I'm trying to answer one. In a proper administration, Mr. Muhammad of ACN, I should be viewing on that body cam 16 independent passes on horizontal engagement segments. When I view this horizontal engagement segments, I didn't see 16. I only saw 4 passes. That means 4 are missing. The first 4 they're missing is the equal pupil size we're talking about, the equal tracking we're talking about, the resting of the stagments we were talking about, the medical qualification for Mr. Parton to either do HDN and go on to a walk and turn. That's what we're talking about. He was never medically qualified to go any further. That's how I knew, by watching the mechanics of administration of HDN.
Okay, thank you.
Thank you, Judge.
Sir, you were never there, or
No,
you didn't smell the odor of intoxicants?
no.
Continue, Mr. Mohammed.
Well, Judge, he stopped and he looked at his attorney, so I turned around.
There's nothing going on. Next question.
Did you observe Earlier on direct, you indicated that there was complete instructions given in regards to the walking turn, correct?
Yes.
Did you observe that? Did you observe, not in relation to the instructions, did you observe the SFST
Did I?
in regards to the walking turn? Did you observe that on the body worn camera?
On the body worn camera, I believe there's two cameras in this case. There was a patrol car and a body worn. So the actual walking part, if I can remember correctly, was on a secondary camera watching his feet. If I remember correctly. Or it might have been on the body camera. I'm sorry, I might have a couple cases confused in my head at the moment, but.
Sir, how many cases are you hired at the current moment?
I have about 7 active cases right now.
Is it common for you to confuse cases?
Sometimes I do. Not a lot of times.
But it's possible. I mean,
Anything's possible, yes.
you have a number of cases you were an expert on, correct?
Yes,
And so you've read a lot of reports, fair?
I do.
And majority of those cases are OWIs, correct?
Yes,
In this case, it's an OWI.
yes.
Earlier here on cross-examination, you confused this case with another, correct?
Earlier? You mean just
now.
Yeah, just that, yes.
And is it common for you to confuse the facts?
No, it's not. No, I'm fatigued, to be honest with you. I really am. I'm fatigued.
And you say your being fatigued could potentially hinder your ability to give a fair opinion in the case?
It can. I'm just not saying it has.
And sir, I really,
Mr. Mohammed,
My
let him
apologies.
finish the answer.
my apologies. And sir, I really appreciate.
Let him finish the answer. Finish the answer, Mr. Crowder, please.
It can, Your Honor. Being fatigued, it can
Okay,
with I'm very tired.
all right, thank you. Mr. Mohammed, next question.
I understand, and I appreciate your honesty, sir. Is your fatigue hindering your ability to testify in this case right now?
No,
But it's caused you to confuse the facts of the case briefly earlier,
just briefly on which camera was being used. That's all.
and whether or not walking turn was conducted.
We already talked about that.
Was a walking turn test conducted in this case?
It was administered in this case, yes.
Did you view it on the body worn camera?
Yes,
There was a pause. May I ask why?
because I had to think in my head, which view I'm thinking of, how he was walking when the officer stopped walking. I have to view if I was walking from a camera or his body camera, I watched him pause. So I just had to think about it, that's all.
Do you recall where this test occurred?
Where? No, I
Yes.
don't.
Was it on the road, on the sidewalk,
I believe a parking lot,
a parking lot?
off the side, or the side of the roadway.
Sir, you just changed your answer, and may I ask why?
I'm sorry,
You just changed your answer. May I ask why?
because I couldn't recall right off the bat, the stopping sequence of this particular evaluation. When Mr. Parton was stopped, where he actually pulled his vehicle over. Now I'm recalling it was roadside, he was pulled over.
You just indicated you couldn't recall. Is that due to your fatigue?
Yes,
And so it is hindering your ability to testify right now
on certain things,
on
yes.
certain levels.
Not on the administration interpretation of field sobriety, but the details of your case on little things, maybe.
Would you say on walk and turn as well?
No, I.
So you were-
Mr. Mohammed, let him finish testifying before you ask the next question, please.
I understand. Go ahead, sir.
The officer gave proper instructions for walk and turn. I didn't say that he didn't.
Okay. And what did you observe in this walk and turn?
What did I observe?
Yes.
He made an incorrect number of steps.
I'm
Sorry.
sorry, who was he?
Mr. Parton.
Okay,
So you observed the defendant in the video.
Yes,
You observed him attempt to conduct this walk and turn, correct?
yes.
Okay. Go ahead and let us know what you saw, and as an expert, what you were able to identify that would show impairment.
Well, first of all, these are not impairment tests.
Tell us what you saw, sir.
Okay, on the walk and turn, What I did not see is him stepping offline in the instructional phase. I did not see him starting too soon. Those are first two clues of the walking test. There's the instructional phase and there's the actual walking phase. Two clues can be scored in the instructional phase. Stepping offline, maintaining the heel-to-toe stance, and starting too soon. Mr. Parton did not score any of those clues, during the instructional phase.
You indicate, go ahead.
During the walking phase, there's 6 additional clues that can be assessed while you're walking. Taking too many steps, stepping offline, missing heel to toe, raising arms while balancing. These are just various problems the person can have.
Okay, and so you indicated during the walking phase, there's 6 clues.
Yes, there's 6, yeah.
And did you see any clues?
Yes, he scored like five clues. I that was written. I can't say written, but I observed 5 clues in the actual.
5 of 6 clues were present.
5, yes. 5 out of total of 8.
In the walking phase, how many tests are there? How many, what is the score out of? Isn't it 6 out of 6?
No, it's a total of 8 standardized clues in the walk and turn.
On the walking phase, though.
Oh, 6? Yes, sir.
So on the walking phase, there was 5 out of 6 clues, correct?
Yeah.
And what are those clues indicative of, in your expert opinion?
Theirs are indicative of bad balance.
And what were the 5 of 6 clues that you had observed?
Him taking too many steps, stepping offline, missing heel to toe, raising arms to balance, stepping offline, heel to toe, raising arms, improper turn. I bet noted all those, yeah.
That's 4. Okay, you can count.
Stepping offline, missing heel to toe, raising arms to balance, too many steps, stops walking.
What was that last one?
Stops walking, stops while walking.
Okay, is that similar to failing to listen to instructions?
No, it's just you pause during the evaluation, just like the officer paused and stopped during this demonstration. Mr. Parton stopped too, he paused.
And in that video, did you observe the defendant tumble onto the officer?
What's the word, sir?
Did you observe the defendant at some point during the walking phase kind of tumbled onto the officer where the officer kind of had to hold him up? Did you observe that portion?
A tumble, he did a sidestep from the actual, while he was walking. I wouldn't call it a tumble, no.
A sidestep?
Like a sidestep stepping offline, yes.
Did it lead him to have physical contact with the officer?
But, well, the officer, tried to help him, so.
Sir, it's yes or no? Did it lead him to have contact with the officer?
It didn't?
Not that I'm aware of.
Oh.
Okay, it seems as though you're going to want to play the video, correct?
Yes.
Let's take a break so everybody I'm going to presume people have to use the restroom. So let's all rise for the, actually, hold on, Mark, before we do that. Mark, will you just throw a sticky note up on that bottom one, please?
I'm sorry.
Can you just put a sticky note up on that camera? So, no, not that one, not that one. No, another one. Grab, no. Grab another sticky note and put it on that bottom camera right there, please.
All right. Put it on the bottom one.
Oh, there's the thing, the sticky note. Right here. Yeah. That's right, Scott.
Roll out.
Just put it right on there, please. Yes, that one. There we go. Perfect. All right, that way. All rise for the jury. We're gonna take about, we'll resume at 11:40. That way it gives everybody time to use the restroom. The jurors only have one restroom in there they have to rotate through, so. All right, let's go off the record and we will resume at 11:40.
Thank you.
Mr. Corrado is resumed at the witness chair, and then Mr. Mohammed, you have you pulled up a video. You want to screen share that, correct?
Yes, Your Honor.
All right, and then just please, as a reminder, indicate the time that you are starting and pausing the recording.
Of course. And just as a couple questions before I get to publishing that and asking some questions. I think, sir, we left off at the walk and turn test. You previously indicated, and correct me if I'm wrong, 'cause my memory isn't perfect, but that you had observed the defendant conduct the SFSTs, correct?
Yes.
And I was asking you some follow-up, some other questions prior to that, because it appeared that you were tired and there was some confusion as to cases. And so I want to because I want to make sure that we're talking about the same case. And so in this specific case, you indicated that you had observed the SFSTs. Now, where exactly was this SFST in regards to the walk and turn conducted? Was it the Parton?
Objection asked and answered, Your Honor. He asked it before we took a break. Hands,
What question specifically?
the question of where did the standard field sobriety test take place?
Yes, he did ask the question. And so I'm giving Mr. Mohammed a slight bit of leeway just to refresh the record because we've taken a break. One short little bit, Mr. Mohammed, the court's going to overrule the objection.
Thank you, Your Honor. And sir, do you recall where this occurred?
It appeared to be some sort of sidewalk.
Okay. And you indicated that you had observed the defendant do the walking, but you had not observed him, make any physical contact with the officer or veer to the left or something of that nature. Is that correct?
Mr. Parton veered to the left, and it seemed the officer lunged to appeared to catch Mr. Parton, but I didn't know if any physical contact was made.
Sir, did you discuss the testimony now? Since the last break, had you had any discussions in relations to what you're testifying to now?
Oh, absolutely not.
And have you watched the video or anything of that nature?
No, sir.
So it seems like it's so what you're saying is you don't know if there's any physical contact?
No, it was really hard to tell from the video from what I was watching. You can see the action made, but I don't know if any contact was made.
And what do you mean by you see him veer left? Can you just clarify a little further?
It was like a sidestep on the walking to the left. It was kind of a shuffle foot, and the officer just made an invert action to help somebody, like step out and try to catch as he was doing the.
So you observe the officer basically try and catch the defendant from falling?
Or sidestep, yes.
Well, would you say that
I don't know what the end result was gonna be.
Mr. Grotto, please let the attorney, you paused, you were done with your answer. Please let the attorney finish his question first.
prior to the catching, did you observe a sidestep occur?
A sidestep occurred, and I don't know if the catch occurred. If you're at physical contact, I don't believe any physical contact occurred.
So you don't believe that any physical contact?
You didn't, you couldn't tell from the video.
Is that a yes or no?
That's a no, no physical contact occurred.
How are you so confident?
I just remember, I'm remembering the video, sir.
So just to confirm, to your testimony here that there was no physical contact in the video you observed.
I didn't see it.
Okay. I'd like to draw your attention to the screen
All right,
and publishing, which is a video labeled Axon Body number 4 video 2025-10-02-0050 V01AG1729. I'm publishing from 7 minutes and 36 seconds. And this is a previously admitted exhibit. Playing now. Pausing at 7 minutes and 44 seconds.
excuse me 1 second, Counsel. Are you intending to not have any audio?
No, that's why I paused.
Okay,
'Cause I want to fix that. And Judge, I'm going to. Sorry, I'm hitting the pause and it's not pausing. Okay. Oh. So I'm just going to reverse or go back to 7 minutes and 28 seconds, and I'm going to publish to the court from there.
All right.
Small series of steps to turn around, 9 steps back.
Okay.
When you're ready, you may begin.
So you said go.
Just like I
Steps.
explained it.
Okay. Oh, okay.
Alrighty, perfect. Are you?
Pausing at 8 minutes and 31 seconds. And Judge, I'm going to go further back because I believe there was another portion prior to this.
This is becoming cumulative in nature. This was played during the initial phase. And what it's doing is putting up their emphasis on the walk and turn test.
Well, let me just ask this question. What is it you are wanting to ask this witness with this video?
Well, I'm impeaching the witness. He indicated that there was no physical contact. Earlier in the video, it displayed.
Well, hold on. I can't have you testifying as to what so right now you're testifying, counsel. What in this video is what questions do you want to ask this witness regarding this video?
Contradicting his current statement under oath that he's testifying to, that there was no physical contact with the officer.
Okay, so at what point of the video are you indicating there's physical contact so that that's the part you can play and then ask the witness testimony or questions, not just playing from wherever it may be?
Yes, it's at the start of the walk and turn test, but I just clicked it a little further after that, so I'm just going to go back.
Okay, and what, Mr. Bulahanis, is your,
Yeah, that's a mischaracterization of
what's a mischaracterization?
his statement is a mischaracterization of the witness's testimony. He indicated that he could not see any contact on the
He
video.
testified, no, I did not see any contact. So Mr. Mohammed is attempting to impeach
Oh, yeah.
witness's testimony.
As long as it's specifically about that particular.
Correct. That's why I asked what part of the video, and Mr. Mohammed indicated that it must have been before where he started. So I'm going to give you some leeway and put it on that particular moment that you're referencing.
Thank you.
We're not playing all the way through again.
I understand. Okay. Judge, publishing from 5 minutes and 6 seconds.
Perfect. Alrighty, I'll have you stand. Yeah, you can put your glasses back on. Yep. I'll have you stand right here. Right in the middle of the square, right where my foot's at. Perfect. Face that way, just like you are. Beautiful. Alrighty, so what I'm gonna have you do, I'm gonna have you take you're gonna imagine that there's an imaginary line right down the middle of the sidewalk, okay? What you're gonna do is you're gonna put your left foot on that line, right foot right in front of it, heel to toe, just like this.
I'm gonna tell you because of my neck,
Uh-huh.
That's me hard, so I'm just saying.
Okay,
that,
that's
so-
fine. We'll take that into consideration.
Okay.
So again, you're going to keep that left foot, boom,
Yeah.
planted right on that imaginary line. You're going to take your right foot, put it right in front of it. Arms at your side, just like this, heel to toe. Can you get in this position for me?
Sure.
All righty, go ahead.
Is
Get,
that good or no?
nope, I'm going to explain it again.
No, I'm asking, is this okay?
There's imaginary line.
Okay.
Left foot,
On the concrete, okay.
right foot, right in front of it, heel to toe, just like this. Whoa, hey, don't fall over, everybody. Let's try again. Let's restart. Ready?
Mohammed,
Not
you should have
ball.
been right there and paused right then.
Feet together, arms at
You
your
should not
side.
have stepped away from
Imaginary
your
line,
computer.
right down in front of you.
Well, Judge,
Left foot
I'll
on
shed
that
some
line.
light as
Right?
to
No, press pause.
pausing at 6 minutes and 20 seconds. Judge, I moved away from where I was standing so I don't hinder the view of the jury. I'm
Okay, then you
saying
should have then you should have taken your computer with you. Because I said only play that exact portion you're trying to impeach the witness on. All right, you may proceed with your questioning.
Sir, at some point, you just observed the video, correct?
I did.
And you observed the officer's hand make contact with the defendant.
I can't be sure if he touched him. I don't know.
I'm going to highlight the last 10 seconds of this, last 20 seconds of this clip. I'd like you to pay attention to the right side of the screen and see when the defendant veers off of the lane. Please pay attention to that.
Also, if you're stepping away from your computer, please, if you're stepping away so the jurors can see, please take the computer with you.
Playing from 6 minutes and 1 second, and just for the record, I moved my laptop screen as well
Thank you.
from the jury speak. But no,
Imaginary line.
Okay.
Left foot, imaginary line.
Okay.
Left foot,
On the concrete,
imaginary line.
okay.
Left foot,
On the concrete, okay.
right foot, right in front of it, heel to toe, just like this. Whoa, hey, don't fall over, everybody.
pausing at 6 minutes and 9 seconds. Officer, did you, or laptop lead, Mr. Peroto, did you observe the contact?
I don't think there was contact, no. He said, whoa, but I don't think he touched him.
You didn't see his hand make any contact with the defendant?
I saw a hand, and I can't tell if it touched him or not.
Okay. Sir. How is your vision?
I don't know exact numbers, but my vision's okay. I saw a hand on the screen, but as far as physical contact, I can't say, well, 110% certainty they touched each other. That's my answer.
And you're currently wearing glasses, correct?
I do.
Are those prescription glasses?
They are.
And were they prescribed by a medical physician?
Yes.
And was that based on an evaluation that I'm assuming that you took?
Yes.
And they determined that, I'm assuming, and correct me if I'm wrong, that it was necessary for you to wear glasses, correct?
Yes.
Did you have poor vision?
I had vision that needed corrected to 20/20. Yes, sir.
And so you would say, okay. When you watched this video the first time, were you wearing your glasses?
Yes.
You recall that with certainty?
Yes.
Are you farsighted or is it for reading?
Both.
Okay. Where are you domiciled?
I'm sorry.
Where are you domiciled? Where do you,
Objection, Your Honor, it's irrelevant, and ask Mr. Mohammed to take the screenshot down as well.
Okay,
No need for it to be playing right.
all right. So two things. One, are you done with the video, counsel?
yes, I'm
Okay,
going to stop hearing it now.
all right, thank you. And two, what's the relevance as to where this witness is domiciled?
Earlier, he was testifying on direct examination, and he slightly confused the laws of a different state with the laws of this state or the SFSTs when he was making that. He said, oh, we're in Michigan. And so I'm going to follow up on that and explore that to see where he's domiciled and how how familiar he is with with that state's law versus this state.
Okay, I don't find where he's domiciled and the familiarity with where he's domiciled to be relevant. If you want to ask specific questions as to how familiar he is with Michigan law, then that's one thing. But we're not getting into where he's domiciled in that. So the court's ruled that objection's sustained.
And just to clarify for the record, I was not referring to like his actual address, but just the state and the SFST rules in relation to that.
I understand. The objection still sustained.
Okay. Sir, in regards to the SFS earlier on direct examination, you had confused, I believe it was the SFST rules in relation to the state of Michigan. Can you clarify?
Yes, it's not the SFST rules and the state of Michigan. I had to play in my mind the finger dexterity test and how it relates to roadblocks. In the state of Michigan, roadblocks are illegal. Michigan besits. I had to run that through my head, and I kind of spoke ahead of myself saying, well, you're not going to see that in Michigan. That's all. That's all I was referring to.
So there's a difference between states.
I'm sorry?
There's a difference between the different states.
As far as roadblock procedures and legislation, yes, roadblocks are legal. There's no roadblocks in the state of Michigan. I know that. From my practice, I do everything. That's all I was referring to when I misspoke. I didn't misspeak. And you were just saying, you're not going to see a finger dexterity test hanging out a window in the state of Michigan because you don't do roadblocks here. That was my point.
And I understand, and thank you for clarifying, sir. And just to clarify, I wasn't suggesting that you did misspeak. I was just trying to explore and understand what you were trying to say in that moment. If that makes sense. So, sir, in your expert opinion, would you say that drinking alcohol could cause impairment?
Your Honor, I'm going to object. He's not been qualified in this area. He's qualified as an expert, as we agreed to, in the interpretation and application of the standard field sobriety test. That's what he's an expert.
Okay, and your response to that, Mr. Mohammed?
I would actually agree with defense counsel, so I'd move to strike that question.
Okay. Question stricken, most objection sustained.
Just to confirm, you indicated that you observed 5 of the 6 clues in regards to the walk and turn.
Yes, the court's going to sustain the objection as asked and answered.
All right.
Presuming that's where that's coming, right? Was that what you were going to say, Mr. Bulahanis?
Yeah, sure.
All right, very good. I've already sustained it.
Thank you. Nothing further.
All right, redirect.
I just have a few. Now, the standard field sobriety test, that's the national standard.
Yes, it's taught the same here in the state of Michigan as it is in California, the state of Florida. It's a standardized and systematic program nationwide. Actually, worldwide.
Okay. So I just wanted to clear that up.
Yes.
So. Okay, so I just want to go back to one part of the cross-examination, because I might have created some confusion here. Is there a reason that the horizontal gaze and stagnance test is the first test that's given by a police officer?
Yes.
I'm going to object. That goes outside the scope of cross-examination. I didn't ask about what was the first test offered or anything of that nature. That's outside the scope.
It's, if you give me a little latitude, Your Honor, I'm gonna connect it up with, what was done on cross-examination with respect to the horizontal gaze, the status test, the cross-examination questions asked by Mr. Bowman.
Then ask that question. So the court's going to sustain the objection. You can ask the question that relates, that is within the scope of cross counsel.
Okay. So, do you recall, Mr. Mohammed asked you, whether or not you, saw the, defendant's eyes during cross-examination? Okay,
I'm sorry, what was that answer?
Yeah, he did ask.
Yes, okay.
okay. Now, when you explained to him, I just want to make sure the jury understands this. You explained to him that you didn't see his eyes, correct?
As far as pupils, no, I didn't see the pupils, no.
But, and you indicated, that you determined that, several of the passes that were required under the, horizontal gaze and status test, a total of 16 passes, is that correct?
Right.
And you indicated that you observed, 12.
12.
Okay,
That means the first 4, which is the medical clearance, medical qualification, were omitted.
okay. And so, based on that, is it,
Judge, I'm going to object in relation to anything regarding medical related. He's not been qualified as a medical expert to make a determination whether or not the defendant is medically qualified. It's just simply not in his
That wasn't the
realm.
testimony, counsel. The testimony was on your cross-examination that, and I think even on direct, that the officer has to medically clear or medically qualify an individual before they conduct certain SFSTs. One way to do that was by the number of passes or something of that nature, is what the witness testified to. He's not that, and that is what this line of questioning is for, not whether or not somebody's medically qualified to diagnose somebody. That's what this line of questioning is. That's what the line of questioning was.
Yes, so I would just object if he's giving an opinion whether or not the defendant was medically qualified or was not. He's not in a position to make that determination.
Correct.
Okay.
He's only provided testimony thus far that I've heard as to whether or not the officer followed the proper procedure per the testimony of the witness, as to whether or not the officer medically cleared or medically qualified or whatever the language is supposed to be used, the defendant before administering the SFSTs.
Understood, thank you.
Yes, so
That was
objection
exact-
overruled.
thank you, Aaron. That's exactly my point.
Okay,
So, you were able to determine that just strictly by the number of passes.
That's correct.
Okay. So, as a result, if that doesn't occur, what does NHTSA, what's NHTSA's, determination of whether it's a valid HDI test or not, in your expert opinion?
On this objection, Judge, this is outside the scope. I didn't ask him about what NHTSA's conclusion as to certain tests are. That there was nothing about that in regards to cross. So I think it's a good question, but I just think it's outside of the scope.
your response, Mr. Bulahanis?
Your Honor, he did ask him about the passes and so forth, and, whether, the officer did the right number of passes, so I was doing it based on.
Right, but Mr. Mohammed, I'm pretty certain if I recall correctly, because I'm paying attention, didn't even ask the witness anything about NHTSA. So
I'll move on.
we're going to sustain the objection.
Thank you, Your Honor.
Thank you.
Now, Mr. Prado, Mr. Mohammed asked you, if you were paid for, your expert services, correct?
Yes, he did.
And so that's a common practice, is that correct?
Yes.
Okay. You're not a charity, correct?
No.
Okay. And so, in respect to this particular case, Can you estimate the number of hours you expended in preparing for this case for your testimony and then traveling to Michigan on 3 different occasions? You give us a ballpark figure of how many hours you've expended?
It would be difficult to put in hours. It's a lot of hours. Doing 3 trips and analyzing the case in details, it's many hours.
Okay. And then, you indicated that you started with last week, right?
Yes, that's
Okay. Now, did the fee that you charged have any impact on your expert opinion today?
absolutely.
Okay. And if you, reviewed everything and you saw that the officer had done everything correctly, that would have been your testimony.
That would be my testimony. Absolutely.
And, Ms. Mohammed reminded you that you were on oath. You understand that, you've been,
Is that yes?
is that a yes?
Yes,
Okay.
Okay. And you've been in a courtroom before, correct?
yes, I have.
And you've been qualified in over 300 courts, correct?
Yes.
Okay. And is your testimony different because, it's involving a defense?
No.
And if the prosecution had hired you, you would
I would
have testified that
Hold on, Mr. Corrado, please let the attorney finish the question first.
if the prosecution had hired you in this case, would your testimony be any different?
No,
Thank you.
Recross.
Very, very brief. There. How many hours of sleep are you on?
I'm sorry.
You indicated you drove here 10 hours.
Objection beyond the scope of,
The court would agree that was on your cross-examination, not on Mr. Bulahanis's redirect.
Well, Judge, on redirect, he was asking questions in relation to, the types of questions that are being asked. While it might not be something verbal that he said, it's my observations of him during cross-examination.
That's not within the scope. Your observations of the witness's, body language, that, if it was not asked on redirect it's outside the scope on recross.
Well, defense counsel was asking questions in relation to the witness's reliability as far as income and money. And so my question kind of stems from a similar basis. I just want to ensure that.
No, counsel. I've ruled on the objection. It's sustained. It's not an invitation to continue to argue with the court and then to continue to offer what it is you're trying to get. So the court has sustained the objection.
I'm not, and Judge, just for clarification, my intention is not to argue with the court, it's to make my record and
Okay,
put it forth before the court, and I will respect your decision, Judge.
Okay.
Nothing further from this witness.
all right. Anything further?
Your Honor, I would just ask that, I think the court has admitted defendant's exhibit A, correct?
I did. It's admitted
We
and
ask that it
published.
be published to the jury at this time.
Okay,
And Judge, just for the record, I would object on the same grounds that I did earlier.
okay. The court, and the court did, admit defense exhibit A through page 84. And so, the court will, you want the jury to read, did you bring copies for all the jurors?
No, I didn't bring, I do have a couple copies, Your Honor.
Or do you want that to be, you want them to look at that right now, or do you want that to be available if they so choose during deliberations?
Well, so, I wouldn't mind that they got a chance to look at it now, just briefly, Your Honor. Or they can,
Well, we'll reserve it in the event that they want to look at it during deliberation.
I appreciate it. Thank you so
All
much.
right, are there any questions by any of the jurors, for this witness? No, there are no questions by any of the jurors. All right, any further, and so is this witness excused?
This witness is excused for defense rests.
Thank you, Mr. Corrado, for your time and your testimony today. Thank you. Are there any rebuttal witnesses?
No.
Okay, so this is a great time to break for lunch. It's 12:30. We're going to resume at 1:30. Okay? So what we're going to do is we're going to all rise for the jury. Put that, back up there. Perfect, thank you. Our high-tech, stop. Let's go off the record. And so, Mr. Mohammed, you may proceed with your closing statements. You may adjust the podium to face the jurors if that's where you choose to sit.
Understood. Thank you. So, ladies and gentlemen, first I wanted to thank you for being with us throughout the course of this jury trial. I know it's kind of lengthy for being only 2 witnesses, but I'll just get straight to the point. So in this specific case, you had the opportunity to hear the testimony of a police officer. You also had the opportunity to hear the testimony of the defendant and the testimony of the defense's expert witness. And in this specific case, I'm going to highlight some specific points I'd like you to take note of, and that would start with the reason for the stop. And so the reason for the stop, as we learned from the police officer, was that he had observed the defendant, the vehicle veering to the left. That initially grabbed his attention. And what we call that in the field of law is called reasonable suspicion. And that gives cause for a police officer to conduct a lawful traffic stop. Now, what that means is that the officer had observed the vehicle veering to the left, and he also testified that based on his training experience, that type of movement is related to operating while impaired. Now, he's not, at that present moment, it's not the officer's position that he was intoxicated. What it did is it gave him suspicion, and it was reasonable suspicion. This was nighttime, there wasn't other vehicles, and he was observing this vehicle veering to the left in a manner that's not consistent with how vehicles are supposed to be driven on the roadway. We know that because the officer also testified that that alone is a ticketable offense. Now, at that point in time, there wasn't what we call probable cause, or there wasn't beyond reasonable doubt that he was driving while impaired or intoxicated. All it was at that point was reasonable suspicion. He was just suspicious. He had a hunch. And so conducted a traffic stop. And when he did that, he approached the vehicle and he made contact with the driver. The driver of that vehicle was the defendant. Now, in that point in time, the officer's suspicion could have been dispelled. It could have been, okay, maybe he was just holding his phone, or maybe he dropped a drink on himself, or whatever the case may be. But his suspicion was not dispelled. And so this is very important because we need to know why his suspicion was not dispelled. The officer indicated, he testified here under oath, that upon making contact with the driver of that vehicle, he could detect an odor of intoxicants. And I think, if I recall correctly, I asked him what that odor was, and he testified, if I recall, it was alcohol. And so the officer, upon his detection of an odor of intoxicants, as well as his conversation with the defendant. Now, I played a portion in the body-worn camera. I can't recall the exact seconds, and you have the opportunity to review it, confirm everything. But the officer also could acknowledge that the defendant's speech pattern was abnormal. He asked him where he was coming from, and there was delays in his statements. There were certain moments, I think the word Riverview was asked, where were you coming from? And just the pronunciation of how he pronounced the word Riverview, it appeared slurred, it appeared abnormal is the best way to describe it. We also had the opportunity to hear the defendant here in court. And when he mentioned the word Riverview, I don't know about you, but I could tell a distinct difference in his pronunciation. So again, those three items, one being his driving behavior, two being the detection of an odor of intoxicants, and three at that point being that his pronunciations and his speech pattern further elevated the officer's suspicion. So what did the officer do at that point? The officer asked him to conduct some SFSTs, standardized field sobriety tests, to make that determination. Is this person impaired, feel intoxicated? Why is he acting this way? So the defendant, which we all heard from, he voluntarily took this test. And we all had the opportunity to see how he performed that test. We all had the opportunity to hear how he was speaking during this interaction. And based on the video, I think we all can use common sense. That was not typical behavior with how he conducted the walk and turn. There was multiple moments throughout that walk and turn. This is a simple test of just walking in a straight line. I think of 9 times, turning around and walking back, and he was not able to do that. At some point, he veered or tumbled, and the officer had to hold him up with his own hands. And that's not the only point I would point to. There was multiple times throughout that walk where he was walking to the left like this, things of that nature. So why is this important? This is important to prove the charge that we have before us, is that not only was he operating the vehicle, but visibly, based on our physical observation, this person was impaired. Now, that being said, that we had the vehicle veering to the left, we had, which gave the officer the reasonable suspicion. The officer had the odor of intoxicants, speech pattern, and that test where the individual couldn't maintain a straight walk path and follow that line. Do we know if he actually consumed alcohol? And we have the best evidence we can have proving that he drank alcohol on the day in question. Not only was there an odor of intoxicants, but it was the defendant's own words. The defendant told us, all of us, here in court, that on the day in question that he had consumed alcohol. He informed us that he went to a bowling alley and that he had consumed an alcoholic beverage. Now, I understand he informed us that he only had 1 drink. And that takes me to my next point, which is the defendant's testimony and whether or not we believe he's credible. Now, in my opinion, and how I viewed the testimony, I did not find him to be too credible. And there was many reasons for that, but throughout the course of his testimony, you could tell that he was changing his answers. I asked him a specific question about whether or not he recognized that the vehicle that he was driving, which led to the stop, was veering to the left. His response was that he wasn't aware that his vehicle was veering to the left. But then shortly after, he was able to give me an exact reason as to why his vehicle was veering to the left. Now, if you don't know you're doing something, how do you have an explanation for why you're doing it? These are the types of statements that were made by the defendant that led me to believe that he was not as honest as I thought he would be. In particular, I thought that he was potentially not telling the full story. Now, ultimately, that's for you guys to make that determination based on the totality of his testimony. You heard it, you can make your own conclusions. Now, we also heard the testimony of the expert witness, not the people's, and by the people, I mean the prosecution's expert, but we heard the defense. They hired him, they paid for him, over $6,000 to be here, and he testified. Now, what I want to highlight in that individual who's here in the courtroom's testimony, a number of things. The first is that it's their own expert's testimony that during the walking phase of the walk and turn test, that the defendant had 5 of 6 clues. This isn't something that I'm suggesting to you. This is the expert of the defendant, that the defendant during the walk and turn test displayed 5 of 6 clues. Now, I think the number by the officer suggested 7 or 8 in its totality. But as far as the walking phase, the expert testified that he had 5 out of 6 clues. And so these are the facts. These are the statements of the defendant's own attorney. Further, there was another test that was conducted in in this case, and that is the HGN test. Now, the officer testified that he conducted this HGN test, and he identified that there were clues during the HGN test. Now, I understand that the defense presented an expert and he went on to have a different position as to some portions of that, and I won't dive too much into that, 'cause I know you all know what I'm referring to, but I just want to touch on a few things. Number one is that the expert himself identified that there's certain things that cannot be observed through a body-worn camera. In person, when you see someone in person, you're able to identify things a little with more detail. It's possible, and I'm not saying that it is, but there's certain things that might not be covered through the body-worn camera. It's placed around the chest area. It's not placed on the eyes. So if something may have occurred or may have not, that's things, there's certain testimony in this case that suggests that there's things that could have happened without the body-worn camera capturing it. And specifically, I would point to the beginning of this case. There was testimony by the officer that his scout cam vehicle had captured the defendant veering to the left. We saw that in the video. I think it was around the 20-second mark. However, the officer also testified that prior to that video, before it even began recording, he observed that vehicle veering and making suggestions to him that led to the stop. So it doesn't mean that just because it's not in the video, it didn't happen. It means that some things can happen before a video. It could be captured outside of the lens of a video. So I would ask you to just keep that in mind. So ultimately, I do believe that you will come back and you will find that the defendant is guilty of operating the vehicle while being visibly impaired. Now, there's a couple things I want to highlight, and that's in regards to the elements of the two crimes that we have before us. So number one, the defendant is charged with operating while intoxicated. The second crime is that he was operating while visibly impaired. Now, what's the difference? Sound very similar, and they are very similar to a degree. And I would go into the elements of these crimes. Each one of those crimes includes 3 elements. The first 2 elements are the same exact elements for both crimes. And I'll be very brief and just state them. The first element is that the defendant operated a motor vehicle. The second is that the defendant operated that vehicle on highway or other place open to the public or generally accessible to motor vehicles. So in both those elements, they're the same with both crimes. I think it's very clear. I'm not going to spend time going on to how you can make that decision. In regards to the final element, so what makes operating while intoxicated different than visibly impaired? And it's that third and final element. Now, with operating while intoxicated, I believe it's a higher standard. We need to prove is that the defendant was intoxicated. I like to think of this as basically he was drunk. We can make that determination that based on the alcohol he drank, he was intoxicated. And just keep in mind, it does not have to be alcohol. You can be intoxicated from consuming pills and things of that nature. But nonetheless, this is an alcohol case, and clearly we're here about alcohol. And so that is your responsibility to take these facts, your observations, the evidence, the testimony, and make that determination. Did you believe that beyond a reasonable doubt that we can conclude that the defendant was intoxicated? Now, you may think that it's clear that he drank alcohol. I mean, he told us he did it, and it may have affected him, but you can't say with beyond reasonable doubt that he was fully intoxicated. It might not be fully there. Now, that is your determination to make. So technically, you can come back and let us know that the defendant was operating this vehicle and was intoxicated. Now, like I said earlier, there was 2 crimes that the defendant has before us here. The second, which I think is very clear, and that is operating while visibly impaired. And I'll go into what impairment means and things of that nature. The 3 elements, the first 2, the same as the last. And so what is that third and final element? what do I think exists here that's very clear without a reasonable doubt? And that is that the third element, it states, due to the drinking of alcohol, the defendant drove with less ability than would an ordinary careful driver. So that is one of the standards we need to make that we need to decide. When he drove this vehicle, did he do so with less ability than an ordinary careful person, careful driver? That is the standard that we need to measure. Did he operate this vehicle with less ability than would a ordinary careful driver? And I think the answer is no. He did not exercise the ability. He did not exercise ordinary careful care. He drove with less ability than an ordinary careful person. Further, it states the defendant's ability to drive must have been lessened to the point that it would have been noticed by another person. We know it was noticed by another person. The officer noticed it. We noticed it when he's veering to the left. And so that drew the suspicion. Now, what else did we notice that makes us confirm that he was impaired? The tests. We had standardized field sobriety tests that suggested clues of impairment. We had the defendant's statements that he was drinking on the day in question. We had an odor of intoxicants. The officer testified that based on his training and experience as an officer, that he believed this defendant to be impaired based off of his observations. Additionally, the element goes on to say it is the defendant's ability to drive that must have been visibly lessened, not the defendant's manner of driving. Though evidence of the defendant's driving may be considered as evidence of the defendant's ability to drive. And so what that says is that the manner in which he was driving doesn't have to be the reason why we find that he was impaired. But if we do see that there's evidence that of his driving correlated to impairment, it can be considered. So even though we don't need that in this specific case, we have that. The evidence suggests that. And so I believe that when you look at the totality of the evidence, the driving, the odor of intoxicants, the speech, the results of the SFSTs, the admission of drinking, the behavior and speech that was displayed by the defendant. Just look at how he was walking in the walk and turn. All of these in its totality suggests that he was impaired. All of that in its totality to me tells me that he drove this vehicle with less ability than an ordinary careful driver. That is the standard. That he drove this with less ability than an ordinary careful driver. Not just an ordinary driver, but an ordinary careful driver. And so that is what we need to determine. And to me, it's clear. He operated this vehicle and he was visibly impaired. So for those reasons, I do believe that without any doubt that you will come back and you will find that the defendant had violated that crime. I understand we all have personal experiences, some may not in relation to alcohol. Your responsibility as a juror is to look at the evidence, the testimony, you analyze the crime and the elements, and do those facts. Does the evidence, does the testimony fit into this crime? And when you do so, I'm fairly confident that you will come back and find that the defendant is guilty. I want to thank you for your time, and I appreciate all of you, and thank you.
Thank you. Mr. Bulahanis.
Thank you, Alan.
Yes.
As the judge said, that's right, Chair, or and crisis. So, as the jury instructions have been led to you, these everything has the burden of proof behind the reasonable doubt from every element. So, what's the most trustworthy evidence in this case? Most trustworthy evidence is the video. The video doesn't have an agenda. So there is a dash cam and it shows Mr. Parton driving his vehicle. And we gotta be very careful when we pick words. When the prosecutor indicates he veered out of his, the word veer means to make a sudden change of direction. Okay, so I would ask each one of you to look at the video and say, well, I want to see the sudden change of direction. Veer has a special meaning, a special, definition. There was no veering in this case. What occurred is my client was driving at midnight or so. There was no other traffic. He was hugging a line in his lane of travel. There was no other safety concerns. And when he got up and testified, he indicated that he had adjusted his seat. And so that could have been when he was moving to the left of the lane. There's no law that says you have to drive in a perfectly straight line. Okay? So not once, if you watch the video, not once did Mr. Parton cross over into the other lane. Next. As Mr. Parton was signaled to move over to by the police officer when he turned on his overheads, you'll notice if you watch the video that he immediately complied with the response in a reasonable manner. He immediately pulled over and he rolled down his window and started talking to the prosecutor. The officer. So when he talked to the officer indicated that he had odor of intoxication. But when you drink a beer or 2 beers or a glass of wine or something, yeah, you're going to have an odor of intoxication. Well, so that's not surprising. Now, it's interesting that the officer indicated on his direct testimony that his speech was slurred, even though it was not found in his report anywhere. That was not indicated in his report. And as it was indicated during his examination, or cross-examination, that the officers are trained to list all the important information in their reports so they can refer to them at a later date. So that was not in his report. Additionally, when my client got out to do the standard field sobriety test, the expert indicated that the officer failed to administer the horizontal gaze astragalus test, the test with the stimulus and the passing back and forth in an appropriate manner. And that my client was not medically cleared for that test or any other test because of that. And so the expert testimony is that the officer failed to administer the HCM test in a proper manner. That kind of leads to the other test. Now, in the Bodycam, which is also an exhibit, my client immediately indicates to the officer that he's had issues regarding balance. And so that is the reason for his poor testing. So he's testified to that and so forth. And that's the reason why he didn't test in that manner. Now, the HDN test, sworn testimony of the expert witness was that you need 16 passes and the officer only did 12, which means that the equal tracking wasn't done. So that's how they medically clear the person for performing all the other tests subsequent to that. So that wasn't done. So if that's not done properly, if you don't follow the rules, you won't get valid results. So the rules weren't followed. And we have an expert testimony to confirm that. And the prosecutor had the option of hiring an expert witness, could have gone anywhere in the country and hired an expert witness to counter our witness. Never done. And he conceded he is an expert. And so the fact that he was paid, every expert witness in every case gets paid for their time. It's like if you want to work and work 40 hours And at the end of 40 hours, they said, you're just doing something good. And so forth. That doesn't have any impact on it. If the officer performed the test properly, would have testified to that. If the officer improperly performed the test, he would testify to that. And so the expert's been here on 3 separate occasions, as some of you have as well. So now the real interesting part is, as the prosecutor indicated during his opening statement, there's no test. There's no blood test, there's no urine test, there's no blood test. And so that's the objective standard when you find someone guilty on these type of cases. There's none of that in this case. So the absence of the blood test, urine test, and blood test in combination with the inappropriate or improper administration of the field sobriety test, that doesn't leave any actual testimony that would serve to prove that my client was operating as under visibly impaired or intoxicated. When you watch him drive, as I said, yeah, he might be responsible for an improper lane ticket at most, but he's not responsible, he's not guilty of operating while visibly impaired or operating while intoxicated. Thank you.
It's Norman.
So, ladies and gentlemen, I just want to conclude with a few things and with our responses to what the defense attorney mentioned. In regards to the word here, I would concede that people could have different views on what that means. To me, it suggests that an individual shifted to the side. To me, I think that was very clear through the video. Now, we don't always have video evidence of that, but in this specific case, we do. Sometimes we have to rely just on an individual's testimony, but in this case, we have more than that. We have actual concrete video evidence of that. And again, I would ask you to explore that. If we need to review that again, we can produce that for you to make that determination. At the end of the day, you guys are the jury, you make that decision. You can watch it and make that call. I don't want you to take my opinion into consideration when making that. I don't want you to take the defenses. I want you to use your own common sense, because I think that's what this case is about. It's about common sense. And I think when you use common sense, you'll be able to conclude that the defendant was visibly impaired. Now, in regards to the defense attorney mentioning statement about the speech was not in his report. Okay, great. Not in his report. But where is it? It's in the video. It's in the evidence that was entered into this record. You can hear it for yourself. You did hear it. And so, sure, an officer may have missed or forgot to put in a specific word. But we don't even need him to put that. His report is not being admitted into evidence. What has been admitted into evidence is the actual video of the interaction that happened. We have to remember, we didn't always have body-worn cameras. There was a time and day where we didn't have that, but now it exists. So now you can see firsthand what actually happened and how his conduct was. Now, I'll leave you with this. You all watched the videos in this case. You heard the testimony. Use common sense. Should the defendant have been behind the wheel? Is this someone you feel safe sharing the road with? Or do you believe he failed to exercise ordinary, careful care in driving that vehicle? And I think the answer is pretty obvious, but I'll leave that for you to make. I'm confident that based on the testimony of the different individuals and the evidence, you'll make the right decision and you'll make the proper decision. Whether I agree with it or not, we will live with your decision. But I think that when reviewing everything in its totality and looking at it, do you feel safe with this individual, the defendant, on this day in question? Would you feel safe if you were on the same road with him or your family? Do you believe he exercised ordinary care? I think not. Thank you.
All right, thank you. All right, counsel, I'm just going to have you, if you can do one copy to each attorney, please. If you could just review that to make sure that, everything is in there. Is it,
May we approach you on?
okay, let's go off the record. All right, so we're back on the record. Mr. Mohammed, did you have an opportunity to review the jury instructions before we disperse the copies to the jury and begin reading the jury instructions?
I just need one more minute. That's,
Okay,
I'm ready, Your Honor.
okay. And so do those comport with what we all spoke about prior to resuming this afternoon?
Yes, Your Honor.
Your Honor, they comport with the one exception we talked about. I placed an objection on.
Right, which we can address later as
Well,
well.
address later, yes.
Okay, very good.
Yes, sir.
All right, so Dave, if you can disseminate those to the jurors, and then we're going to start on page 1. Autumn, do you have all 8 names in the box? What's that? Do you have all 8 of the juror names in the box? Do you know it? Or do you have them in a spot? Yeah, I'm seeing call it time. So let me know when I'm ready to start. All right, so you all don't go ahead yet. Just, we're gonna go page by page. We just have to we're putting all the names in the box because one of you are going to have the lucky or unlucky name that gets pulled where you don't have to continue. Got you sat for 3 days.
My phone lined up?
No, not yet.
Oh.
I just wanted to just be ready, that's all. Are we good to start back on?
Yep.
Okay. All right, members of the jury, the evidence and arguments in this case are finished, and I will now instruct you on the law. That is, I will explain the law that applies to this case. Remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy, bias, or prejudice influence your decision. You must avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors who may have different backgrounds and perspectives from yours. As jurors, you must decide what the facts of this case are. This is your job and nobody else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I have already given you some instructions about the law. You must take all my instructions together as the law you are to follow. You should not pay any attention to some instructions and ignore others. To sum up, it is your job to decide what the facts of the case are, to apply the law as I give it to you, and in that way, to decide the case. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a dot that is reasonable after a careful and considered examination of the facts and circumstances of this case. Every defendant has the absolute right not to testify. When you decide the case, you must not consider the fact that he did not testify, although in this case, the defendant did testify. It must not affect your verdict in any way. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I will now describe some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. Likewise, the fact that he is charged with more than one crime is not evidence. The lawyer's statements and arguments and any commentary are not evidence. They are only meant to help you understand the evidence in each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses and my questions to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, summary of the evidence, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies to this case. However, when I make a comment or give an instruction, I'm not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I've excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during this trial. Any response given by Shannon Parton when asked whether he would consent to a PBT test is to be disregarded. The jury shall not consider this response for any purpose in its deliberations. As I said before, it is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have and not be influenced by a witness's disability, gender identity, race, religion, ethnicity, sexual orientation, age, national origin, or socioeconomic status. Again, take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth? Or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age and maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in this case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. You may also consider whether the defendant is guilty of the less serious crime of operating while visibly impaired. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant operated a motor vehicle. To operate means to drive or have actual physical control of the vehicle. Second, that the defendant operated the vehicle on a highway or other place open to the public or generally accessible to motor vehicles. Third, that due to the drinking of alcohol, the defendant drove with less ability than would an ordinary careful driver. The defendant's ability to drive must have been lessened to the point that it would have been noticed by another person. It is the defendant's ability to drive that must have been visibly lessened, not the defendant's manner of driving, though evidence of the defendant's manner of driving may be considered as evidence of the defendant's ability to drive. The prosecutor must also prove beyond a reasonable doubt that the crimes occurred on or about October 2nd, 2025 in the city of Wyandotte, Wayne County, Michigan. When you go to the jury room, you will be provided with a written copy of the final jury instructions that you currently have. You should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a business-like way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communications equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately, each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It is your duty as jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own and you must vote honestly and in good conscience. If you have any questions about the jury instructions before you begin deliberations or questions about the instructions that arise during deliberations, you may submit them in writing in a sealed envelope to the bailiff. Possible penalties should not influence your decision. If you find the defendant guilty, it is the duty of the judge to fix the penalty within the limits provided by law. If you want to communicate with me while you are in the jury room, please have your foreperson write a note and give it to the bailiff. It is not proper for you to talk directly with the judge, lawyers, court officers, or other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. When you go to the jury room to deliberate, you may take your notes and full instructions. If you want to look at any or all the reference documents or exhibits that have been admitted, just ask for them. When you go to the jury room, you will have a written copy of the instructions you have just heard. As you discuss the case, you should think about all my instructions together as the law you are to follow. You may return a verdict of guilty of the alleged crime, guilty of a less serious crime, or not guilty. You have heard testimony from witness Tony Caruto, who has given you his opinion as an expert in the field of administration and interpretation of standard field sobriety tests. Experts are allowed to give opinions in court about matters they are experts on. However, you do not have to believe an expert's opinion. Instead, you should decide whether you believe it and how important you think it is. When you decide whether you believe an expert's opinion, think carefully about the reasons and facts he gave for his opinion and whether those facts are true. You should also think about the expert's qualifications and whether his opinion makes sense when you think about the other evidence in the case. You have heard testimony from a witness who is a police officer. That testimony is to be judged by the same standards you use to evaluate the testimony of any other witnesses. At this point, are the people satisfied with the jury instructions as read?
Yes, Your Honor.
The defense?
Defense is satisfied with that one noted objection, Your Honor.
Okay, thank you very much. So now comes the fun part. We will be pulling two names. So a jury of 6 will go into the room to deliberate. So Madam Clerk, if you can please draw the first name.
Michael Zoo.
Okay, and so, sir, you are more than welcome to stay and wait to see what the verdict is, or you are free to leave. Thank you very much for your service. You will receive a letter that you can turn into whoever you need to turn it into, and then you will receive compensation for your days of service. All right, thank you very much. So you are free to leave, or you are free to hang out, whichever you prefer. Okay. All right, and so then the second one, please.
Madison Miskovich.
Okay, and so you heard everything I just said to Mr. Zukowski, and so again, you're free to stay or free to leave, whichever. Do you have anything back there? All right, so just have a seat for just one moment and then we'll get you your items, okay? All right. And so Court Officer Macbeth, I'm going to have you please raise your right hand. You do solemnly swear that you will, to the utmost of your ability, keep the persons sworn as jurors on this trial from separating from each other, that you will not suffer any communication to be made to them or any of them orally or otherwise, that you will not communicate with them or any of them orally or otherwise, except by the order of this court, or to ask them if they have agreed on their verdict until they shall be discharged, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon, so help you God?
I will.
Thank you very much. All rise for the jury. And so I'm just going to ask you, don't begin any deliberations until our two alternates have gathered their items, and then they leave the room, okay? And whoever wants to stay, you can hang out in the lobby or what have you, and then come back in when the verdict's read, that's fine too. Thank you. Okay, and so then, Mr. Bulahanis, if you'd like to just place your objection back on the record that we had spoke about sidebar,
Yes,
you may do so now.
yeah, the objection is asked,
You may continue.
as to the curative instruction, Your Honor. And our motion for a mistrial, we still object to, well, I don't think there can be a curative instruction that unrings the bell. And I stated my position before. I just don't want an appellate court to believe that I withdrew my objection or waived it by agreeing to the curative instruction.
I understand. All right, thank you. Objection noted. Thank
Thank
you.
you so much.
And Your
All right.
Honor, I may respond just for the record. I'd like to place my response just for the record.
I don't think it's necessary, but okay.
Thank you. So Your Honor, I disagree with defense counsel. I oppose their motion as I did previously, and I agree with the court's position. The remark that was elicited or that came out from the video was isolated. It was brief and it was not emphasized in any way. It was not deliberate. There is no showing of substantial harm or prejudice to the defendant. The court, I believe, is making a proper determination by refusing or disagreeing with defense that a curative instruction does not cure the issue. A curative instruction is a directive given by a judge to a jury during a trial. The purpose of that is to mitigate any negative impacts caused by an earlier mistake, such as an improper instruction or introduction of inadmissible evidence. And that is exactly what we have here. It was a mistake. There was no intent by that portion, that very brief clip playing in regards to the response by the defendant. The intent was only to display that a test was offered. It was so short in time, and by the time I had clicked the video, clicked pause, I clicked pause even before it reached that, but I don't know if it's because it was transmitting from my laptop to the streaming service on the screen. But Your Honor, the intent was clear. I started to scream immediately to try and cover up anything coming out of the speakers. I think that the purpose of curative instructions is for situations exactly like this. And so for those reasons, I agree with the court and how it's handled it. I again apologize, and thank you.
You're welcome. And as I did indicate at the time, I don't find that there is any ill intent by Mr. Mohammed for, that
No.
continuation. And Mr. Bulahanis also agreed that there was no ill intent in that regard. It was a technical glitch that occurred and it wasn't as though continued, video, the video did not continue playing. And the court will also note for the record that the court did, independently of with each juror, did bring each of those jurors in independently with counsel present to voir dire that, each of the jurors as to whether or not they heard it. 6 of the 8 jurors heard something along the lines of that. I think, 2 of those 6 heard the verbatim words and the other 4 kind of surmised, from that. So I just wanted to put that on the record as well.
And I'd just like to respond just very, very briefly, Your Honor. And our position too is, my understanding of the law is a little bit different, that neither the offer nor the refusal can be brought in the prosecutor's case in chief, and I want that just stated for the record.
Okay.
So that's the reason for it, and I understand why, I understand what curative instructions are, but I'm not waiving the motion for mistrial.
I understand. All right. Thank you. Okay,
I'm so sorry. Just very, very small detail I want to point out. Because we're relying on the operating law visibly impaired, that doesn't really go to show the visible observations, the elements of the crime. Now, it's something that transpired throughout the case, which is why I wanted to, to show that an officer went through the steps and offered that test, which is why the court, essentially ruled in our favor in part. But I don't think that very short few seconds changes any outcome in the case because that's not an element of the crime. The element is visible impairment.
okay.
Thank you.
All right, thank you. Okay, all right, so, I've already ruled on that, so that's what we're doing. You're all, preserving your arguments for the record, which is what we did. There's a request that they want to see the video already. We have a quick request. So what I'm going to do is, Mr. Mohammed, if you can pull that up, and then there will be a court officer that's pressing play. And there's only a certain time that can be viewed. So I need for counsel, both of you, to state that time together, have it written down, so the court officer is not allowing it to be played outside of those times.
Hey, Judge, do we know which video? Because there's the scout cam video and then there's the body worn camera regarding the SFST.
The dash cam and
We will get clarification on that.
the dash cam can be viewed in a still camera. But that's not an issue.
Okay, I'm going to presume, it's probably both, but I'm not sure.
Well, I didn't see.
Yeah. Offering the test was allowed.
No, it's kind of an interest issue. That's my position.
Both,
Okay,
both.
okay, we gotta sit down and take the time.
Well, I can tell you because I wrote it down at the beginning of the case. So that is, the body cam is 8:57.
Yeah,
So stop at 8:57 and resume at 9:07.
So Judge, if I may, in regards to that statement that shouldn't have come in, and so I'm assuming that's what we just don't want them to see. So we can stop like 20 seconds before we even arrive to that video. I don't think it's going to show too much. So as soon as he finishes the walk and turn, I think that's when they conduct an
I
arrest.
just need you all to decide to
Okay.
agree what time you are stopping it at for, but quite frankly, for the record, the times should be the same as they were that they were viewing during the trial.
right.
Yes, but
So my times that I wrote down that you both stated at the beginning of the trial on March 13th was stopping the video at 8:57, resuming it at 9:07, pausing it again at 9:39, and resuming again at 9:58, and then pausing at 10:25. Those are my notes from what you all had stated.
Yeah, the only difference, I have my notes to you, I was like 2 seconds different than you when it stopped at 8:55. Maybe that was,
we can just stipulate, so obviously for the body worn camera, when you first approach the vehicle and then stop at, what is that address? I think it was 9:30. No, right now we're just on the button.
okay,
The dash you said doesn't matter the time.
Yeah. The dash was,
There wasn't any pausing and stopping on that. It was only the body worn camera.
no, but it might be extended, but the first 50 seconds were, that's what contained any relevant information. 0 to 50.
I don't know about that, but there wasn't any, that played in its entirety, but
Okay.
so we'll play this from the minute and then we'll stop it at. I think this is when he's about to get arrested at 9:36. So it'll be right.
in the jury room, I looked in. And so you'll be responsible for stopping and starting it at that time.
So the placed under arrest. Will you want to take that DPT for me?
See, so it should supposed to stop at 8:57. That's when he asks the question.
Okay, so then if you want to stop it at 8:54, does that work? Look to
He's
the,
okay with that.
look to that to see what 8:54.
Right now it's paused at 8:57. To be safe, I say we go 3 more seconds back.
Okay, so go to 8:50, go to 8:50 and play it through to 8:54.
Okay, 8:50. Yeah, it's at 8:42. I'll tell you when it's at 8:50 then.
Sure,
Go.
I'm requiring you to take DPT, a preliminary breath test. Failure to do so shall result in a civil infraction.
So right now it's 8:50.
Well, I don't think there's just, you can stop right before the PBT even.
Yes, 8.
That's fine.
Or,
Okay, 8:50, that's fine. Well, hold on, what time does he start asking about the PBT? Does he start reading the PBT stuff?
so, I have to go back.
All right, perfect. Are you able to balance on one foot on either toes just like this?
No, I think this is my head.
Because of your neck injury?
Yes.
All right, beautiful. All right, it's the state of Michigan.
So, right, that's when he follows with a statement regarding the PBT, and that's
So what time?
8:42 right now.
Okay, so we pause it, how about we pause it at 8:42?
That's fine.
Will you both agree to that?
Yes, sir.
Okay, so I'm going to write this down on, pause body cam at 8:42. And resume at 9:07, correct?
I don't even think it's necessary anymore. At that point, then it's,
Okay, so just,
another statement about his criminal history,
no, okay, so nothing after 8:42 is being played.
yeah.
Okay, great.
Pretty
There
safe.
you go, Scott.
And don't we have a record right now, or?
Yes.
Okay, so just for the record, because I think defense
I'll
counsel,
give this back to you, Scott.
indicated that, I was, during the case, the testimony regarding that the officer asking whether or not a PBT test was even allowed at that point. He's objecting to even that portion now. And so I just want to highlight for the court and for the record that prior to even beginning the jury trial, I made sure to go through it by seconds, and I stated on the record, and I believe there was a stipulation to me playing it all the way up to that point. So anything about offering the test not being allowed, I would disagree, and I would just point to not only is it consistent with the court's order? But I put on the record the stipulation of time, and there was no objection at that time. And in that specific time that I stated on the record was after the offering of the test, but before the response by the defendant. So I just want to put that on the record.
Okay, all right, on the record. Okay, that's on the record. All right,
Well, I know we have to do the dash cam and that, I think the first 50 seconds takes care of the dash cam. How do you?
Let me see
do that
how-
real fast?
Need to see how many seconds. I don't know if you can see more than 50 seconds.
I don't think so. Never written down.
Do you want to play the body worn camera for them and then bring it back? Or actually, I'll just keep it with you. I'll just show you something.
Let's do the dash cam. That's a separate clip, yeah.
Yeah, I'm just gonna. So you just, is everything else? Do simple.
No, I know, I know.
I'm gonna have it on the video. You just click the button.
Were these at?
For this house.
What's that?
This is driver's seat of this house. Up three.
When that come over.
50 seconds. That's what's rough, like, okay, I'm happy to get this.
All right.
okay. Do you have it all ready to go?
I do for the body worn camera, just the other ones. I don't know.
Well, let's have him do the body worn camera first. Let's do that one first, and then you can bring it back out and you can set it, get the dash camera set.
Okay, I think we got it. So just.
What is the significance in 50 seconds?
To that, yeah, I think he pulls them over. So the initial drive.
Actually, it's even less. 0 to 30 seconds is sufficient. So in regards to this video, 0 to 30 seconds.
That's fine.
Well, whatever was played on the record is what
Yeah,
Scott's going to play.
no, because it's an hour long. I think it's over an hour long. So just 0 to 30 seconds, the whole interaction.
Okay, all right, 0 to 30 seconds. All right,
Pretty
great.
dash.
All right, for the dash cam. Okay, got that, Scott?
Sorry.
Scott, you got that?
Yeah.
Okay, all right.
What was the start time with the first video? It
Okay,
ends-
yeah, so I'll go over it right now. So the first video, I'm gonna show you how to do it. So the first video play at 1 minute. I'm gonna have it, just click play. Okay, so it's at 1 minute. So the first video from 54 seconds, I'm pausing it. And then you're gonna play that to 8:42. So this video,
54 seconds, so.
so you're not gonna have to do anything. All you have to do is you click this button right here. Click that to full screen. You go to play, and then you click that. And then it's going to play. Then you pause it at 8 minutes and 42 seconds. Yes.
And I'm starting at 54 seconds.
Yes, you don't even have to move it. You just click the play button. I have it there ready to go.
But full screen.
Yes, so you click that.
Yeah.
Then you come here and you click that.
So they'll be watching for approximately 6.
Yeah, so you stop it at 8:42.
Yeah, so you're going to be in there while they're watching it. Okay,
And then over here. So over here, same thing. You just click this, click full screen. Once it's in full screen, you press.
It's over here.
Yes, so it's over, so over here is the two lens. This is the body worn camera.
Okay, for right now, I'm just gonna have him do the body worn camera. If he has questions about the dash cam, he can come back out to ask you. I want to get them watching the video.
Okay.
So
Okay.
just
The
the
first one.
yes.
All right, and then we're gonna be off the record.
Thank you, Aaron.
Okay, and the jury foreperson, if you can please stand up, and then if you can please just indicate your juror number, and then if you could please read the verdict.
Juror number 8.
Are you picking him up on him?
It's very light.
Thank you.
Juror number 8.
Thank you. And you may please read the verdict. Counsel, if you and your client can stand up, please.
Your Honor, I mean, there's two, correct? The impaired and the operating while
The
intoxicated?
verdict form you gave.
Yes, I believe there's two, right?
Yes, it's all in very.
All right.
You may proceed.
We find the defendant guilty on the charge of operating while intoxicated and guilty of operating while visibly impaired.
Okay. Would counsel like the jury polled?
Yes, sir.
Okay, all right, thank you. You may have a seat, sir. Juror number 1, was that your verdict?
Yes.
Juror number 2, was that your verdict? Juror number 3, was that your verdict?
Yes.
Number 4, was that your verdict?
Yes.
Number 7, was that your verdict?
Yes.
Number 8, was that your verdict?
Yes.
All right, thank you very much. Okay, what I'm going to do is I'm going to have the jury retire to the jury room for just a moment, and then I will join you in just a few moments, okay? So I'll rise for the jury, please. And I'm sorry, sir, if you can can you grab the verdict form, please, Dave? If you can pass that verdict form, thank you. Thank you.
You'd be seated.
Okay, so, counsel, I know that you were both probably surprised when it said guilty on both, right?
Yeah, maybe.
Because one's a lesser included, but nobody wrote the word or. You all prepared this. The word or was not written on here.
So Your Honor, if I may, in regards to, so my understanding is the defendant can be found guilty of both. However, when it comes to sentencing, one of those counts, the lesser included, would be dismissed. So at the time of sentencing, operating while physically impaired would be dismissed. He cannot be found guilty. He cannot be sentenced on both.
I understand that.
Oh.
I'm just letting you all know that nobody had an or on here. So that's where they're both coming in, because I sense both of your surprise when it's
Yes.
guilty on both, but you all prepared this and it does not have the word or.
Yeah, no, I know.
So in any event, what we'll do is we will, so I'm going to have your client go over to probation, and you all can figure out the next dates for the sentencing date. All right?
Yeah.
All right, bond and conditions are continued. And you all can have a good weekend.
Thank you.
All right, and sir, I'm going to have you come back this way, Mr.